48, no? বসাই দি বসাই দি এইটা কিতাপ ফোনে বসাই দি
Lordship, I beg to mention listing a matter, it is a railway claim matter, Lordship. Kali, Lordship, convenience 11 or 12.
what is the stage?
Says Lordship, it is a after motion notice issued, Lord. This for admission.
Railway claims for motion?
Railway, no, sir, Lordship, it is admission matter.
It's an appeal, isn't it?
No, Lordship, read petition.
Writ petition against what?
Railway death claim. Accident is a railway accident.
How a writ petition?
If there is a provision, there is no any option, any other alternative.
Appeal?
But he is not a passenger, so that come in the writ petition. Already at admission stage.
When writ petition of which year?
Next year, Lord. Last year.
Filed when?
Lordship, it is file last posting it, Lordship, 21/11. File 28/8/2020.
Not that urgent. Sorry. Next.
My lord, I am playing for listing two matters. My lord, one is my lord, objection. No objection certificate has not been issued by the my lord Panchayat department. Panchayat, my lord, is going to be over, my lord. The term of
No objection certificate regarding what?
my lord, for obtaining a timber shop license.
What is the urgency?
My lord, the Panchayat, the term of the Panchayat will be over.
So,
My lord,
how is it concerned? The term of the panchayat will be over.
my lord,
It is not by
no
one
objection
individual.
certificate will be issued by the my lord.
A new panchayat will be there.
That will take time, my lord. So my
No,
lord, in the
no,
meantime,
no,
petitioner could
sorry.
not, my lord.
Sorry. Yes.
My lord, I'm praying for
Obliged.
listing two contract matter, my lord, similar case. Here in this case, stay order is there, but in returnable date is over 3 months ago. So may I pray for listing
For
order?
for payment of bills.
No. It is regarding contract, award of contract,
Okay.
award of,
Okay. We'll have this. Both are similar.
both are similar.
Okay. Yes. Tell us when.
As you
19th.
19. Another, my lord, non-payment of bill, my lord, there already reply has been filed and it is admitted, my lord.
Okay. We'll have it on
admission.
22nd.
22nd. March.
Consequently, I just said I beg to mention one book.
One. Yes.
This matter is going on, Lord, so that might take 3 days. Matter will be listed after this.
We have not understood. Why do you need time?
Lord, because some serious matter is going on, it will continue for another 4 weeks.
Mr. R.K.D.
Yes,
Chaudhary.
Lord.
He also telephoned me that the matter
Okay. When do you want? On 1st of February? Thursday. Or we can have it on 30th of January?
13th
Huh?
February, January.
To 30th, 30? 30 is this 13 matter. 30 fixed it.
Item number 20.
Okay.
In fact, I thought that item 1 will continue.
Okay.
So item 20.
20 is connected or what?
No, this different matter.
Same party.
Same part.
Okay. Okay, 20 will fix another date. Item number
February-
1.
22 matter, February 2nd week or something.
Okay, we'll fix another. First, let us first pass an order in one.
Fine.
A prayer for adjournment has been made on behalf of Sri R.K.D. Chaudhary, learned Deputy SGI. Full stop. Dr. A. Saraf, learned Senior Counsel, is present for the petitioner. Full stop. Since, however, considering that this writ petition is of the year 2013, a short accommodation is granted with a direction to list this matter for consideration on 31. Yes. That will be a Tuesday.
Right.
30. Yes.
Item 20.
Or 20. Yes. Yes. Tell us a date of your convenience.
In the second week, February, middle.
Okay. Hearing matter. Let us have it on 30th itself, or 30th will take time. First.
First, there is a matter 13/2 middle.
13-2,
Tuesday,
okay.
not convenient.
On a prayer made by Dr. Saraf, the learned senior counsel for the petitioner, matter is adjourned to be listed on 13-2. Other side is there?
Well, we inform you.
Okay,
Yes,
okay,
sir, my lord.
okay.
Well, the interim order may continue.
Para, interim order passed earlier to continue till the next date of listing.
I'm okay. Well, I responded to
Okay, your name?
P Hazarika on behalf of.
Sri B. Hazarika Learned Council is present for respondables 2 to 6.
My lordship, item number 16, lordship, daily list. Maybe listed lordship, after vacation. Lord.
After Bihu,
Use it, lord.
on the prayer of Sri N. H. Laskar,
Yes, sir.
Learned Council for the petitioners. Matter is adjourned to be listed after the Bihu vacation. Yes, K. Gogoi, who's there for Union of India? Anyone? You have informed or not?
I'm trying to call.
Oh, that, don't do that.
I-
Prying,
I-
making
I-
attempt, those are not
I will
accepted.
Inform lordship. I will inform lordship.
We will not do. Is it the first time you are mentioning in this code?
No, lordship. I call him what not. I searched his number, lordship, but not found, lordship.
That is not acceptable.
No, lordship, then it,
Let the matter reach. There is no
Oh,
problem
yes,
in granting an accommodation, but without consent, never mention.
yes, lordship.
Yes.
Got it.
Ineligible.
May, but with you consent from other side of it, item number 22 may kindly be passed.
22.
But I take it a complete.
I'm appearing for a petitioner, but some date may be fixed.
Okay. On the prayer of Sri R. M. Das, Learned Standing Council, Water Resource. Matter is adjourned to be listed on
30th January.
In the month of February, Lord, but my target friend.
No, it's a hearing matter. Why? We'll have it on 1st of February.
First of July.
Sri S. Sharma, Learned Counsel for the petitioner is present. 1, 2.
My lord, I beg to mention for listing.
No interim order?
No intent.
Okay.
I beg to mention for listing, my lord, 11. My lord, it is a motion matter, my lord.
Motion, okay, motion.
Obliged.
Please.
But why on 11th?
Why?
Have it on 12th? Friday,
Okay.
Friday, no, not on hearing this. Yes,
Please.
But I pray for listing of it.
read petition. Why?
My lord, the matter already, my lord, I have included my lord as a respondent number 5
Okay, Friday.
item.
Hey, please, your lordship, I beg to mention item number 11 and 12. I'm on behalf of J.K. Goswami Standing Council, APTSA, lordship. We
Okay,
have taken consent from the other side, lordship. Lordship, in item number 11, interim dated 18/12/2023 may be extended.
My lord,
Matter may be taken.
yesterday, my lord, Mr. Jagay Goswami, my lord, informed me, my lord, his father is from, my lord.
okay, no issue. You have also filed an application for what? Vacating?
No, my lord,
IA for what?
modification of interim order, earlier interim order, then on 18/12/2023.
Okay,
it was
okay.
My lord,
modified.
your lordship, my lord, already modified, my lord.
Okay,
Last.
Milord, in this case, in the item number 12,
yes.
AIDC was directed to furnish me a copy of affidavit that has not been cut in the meantime.
In the meantime, we
Okay.
have.
A prayer for adjournment has been made on behalf of Sri J.K. Goswami, Learned Standing Council, AIDC. Full stop. Let these matters be listed after 2 weeks
On 25 January.
on 25th of January 2024. Para interim order passed earlier to continue till the next date of listing.
Must have.
You furnish a copy
No.
to Mrs. Khan. Yes. 25th, they do 11 and 12, both matters.
Right.
Interim order passed earlier, if any. No?
Item number 11, my lord,
Okay, we have passed.
obliged.
I beg to mention for listing of a writ petition.
Hmm.
After vacation, even if in the month of February, Milord, no
No
problem.
matter of which year?
Milord, 23, Milord.
Matter
And
regarding,
this has been issued in the month
matter regarding,
regarding, Milord, my electricity connection was given to somebody else. Against that, I have made complaint to the APTSA. Nothing has
Okay.
been done.
okay, we'll have it, have this on 29th.
If it is a-
Yes,
Lordship, may I pray for listing of an IA?
I
on,
for,
on a contempt petition for impeachment, Lordship. It was filed long back on
okay, we'll have it on Friday.
deeply obliged.
Where's Mr. Saikia?
Made to your lordship. Lordship, I have received instruction, lordship, nothing survived in this IA, my lord. The tender has cancelled.
Cancelled.
Thank you.
Yesterday, I was under
Obliged.
the impression that it was still survived, so I have submitted before this honorable court for personal appeal of the director also, but I have received the instruction in the evening, it was cancelled. my lord. On 6th, it was cancelled.
Heard Sri R.C. Saikia, yeah, I had him, huh? Learned counsel for the petitioner. Full stop. Also heard MS MD Bora. Learned standing counsel.
WMD department,
W,
MD, Welfare of Minorities and Development Department.
not Chararias.
Yes, including the salary.
What is it?
Oh. No, what is the name of the department?
Welfare of Minorities and Development Department.
Welfare
So
of
it is under-
Minorities and Development
Department.
Department. Full stop. When the matter was taken up yesterday, comma, the following order was passed. Para. Accordingly, comma, this matter is listed today for consideration. Full stop. Para. MS Bora, the learned standing counsel, however, has informed this court that the e-procurement system published on 20/12/2023 is cancelled in terms of the interim order earlier passed by this court on 12/4/2023. Full stop. Copy of the aforesaid office order dated 6/1/2024 is also placed before this court. Full stop. Para, in view of the above development, comma, this court is of the opinion that there is no requirement for any adjudication in the IA. Full stop. IA accordingly stands closed.
Madam,
Your blessing.
A copy of the order dated 6/1/2024 is kept with the records. Give a copy.
Lordship, Lordship may give this copy as a part of the, I have a copy.
No, you give a photocopy.
I,
Don't give the original. Original is for you.
this is for- Lordship, Lordship may kindly fix the petition in a short early date, my lord.
Okay,
With-
uh,
There is urgency in
okay,
our part also.
Okay.
that has been fixed on 22nd January.
We have filed affidavit, petitioner has taken time for filing reply, but no reply is filed till today.
Okay, 22nd we'll have it.
Lordship may kindly dispose of the petition because we
Okay,
have urgency,
Okay, first let 22nd arrive.
Yes.
my lord. Deeply obliged, Lordship.
Complete. It's a great relief to the petitioner.
Temporary relief.
Temporary.
Writ petition will be dismissed.
Deeply obliged, my lord.
If the workman did come as directed by your lordship on the 20th, and he's been working in the garden since then.
Okay. Now what is there? Anything there to be?
No, only I think the back wages, lordship. Back wages, the point is he's been gainfully employed elsewhere. That's the instruction I have.
No, there is no painful.
But he is-
Welcome.
But that is there's no affidavit on the part of the workman stating the point that he has not been engaged.
Where is your affidavit, Mrs. Sinha?
There is no affidavit.
Then in that case,
Because
But also the back wages at the time of passing of the judgment, that may become.
okay, that, what about that?
Lordship, how can that be? Because the workman has to prove that he is not engaged elsewhere. He cannot get double wages.
For that lordship, petitioner has, in his written statement, he has said he has not employed anywhere.
Written statement was long ago, Lordship, now. And he is engaged.
Now
but
we
that's
can
it.
hear this for that issue. We can hear this. We can, these are all matters.
In that even, Lordship, I'll file a short affidavit because I'm getting the material to show that he's engaged in a neighboring tea state. And I'll put that on record to show that he has been employed.
No, that is the primary ground on which you have structured this writ petition.
Yes, doctor. That's my ground.
Now, where is the requirement or
But
for
he-
filing any additional affidavit?
No, because he says that he has not been engaged by the
No,
court.
there is no affidavit. Why should we?
Absolutely. Then Lordship can hear the matter.
Yes.
Lordship, what has
In
happened?
absence of pleadings by a writ court will not go by his oral submission.
Yes, Lordship, what has happened in this matter was that the petitioner, the workman was employed in the garden. Even his father was employee of the garden.
You are for the management.
For the management.
Okay,
Then
just.
what has happened is that after the father retired, after his retirement, he was re-employed and he was made the chowkidar of the gates which sit near his house.
The father.
The father. Then thereafter the father retired. Then
Father was
uh,
earlier
yes,
working with the garden.
garden. He is Joy Narayan Koiri.
After his retirement, he was made to work. He was given the work of sluice gate.
Yes, as a chowkidar there.
He retired as chowkidar.
He retired there after Lordship. In the meantime, the petitioner was working.
Hmm.
After his father was retired, he wanted the job of the chowkidar, which we refused to give him. He had other works. He was a laborer, daily rated laborer in the garden. And after we refused to give him that work and were given him other work, he refused to come to the garden. He refused to work and he's been absenting himself. Thereafter, he raised a dispute. The matter went up to the industrial tribunal. And Lordship, the industrial tribunal award is at page 24, annexure 4.
He had raised through some union.
Yes, Lordship. Initially, he had raised it to the union, but now he is fighting it on his own. He raised it to the General Secretary, Kachar Shah Stomach Union, Silchar.
Your name is Joy Narayan Koiri?
Jainapur.
Okay.
Then, Lordship, the following issues were referenced at
Page
page 24, Lordship.
24.
24. Say what's it? Whether the management is justified in dismissing Joy Narayan Koiri from the service with effect from 29/11/2003 SLA. If not, what relief is entitled to? Whether the management is justifying issuing absentee notice to Koiri for not attending his duties. If not, what relief is the workman entitled? Thereafter, Lordship, the evidence, written statements were filed. I can take your Lordship straight away to page 25. By filing the written statement, the management, paragraph 3, the management of Lalamok Tea Estate states that the order of reference is invalid and bad, having the government failed to comply with the mandatory requirements of law for commencing the industrial dispute. The government failed to send a copy of the statement of the dispute to them, which is synonymous with any industrial dispute. There is no cause of action for the reference, and the very reference is misconceived. And in result, the tribunal has no jurisdiction to adjudicate upon this illegal, invalid reference. As such, the issue and relief are vague and indefinite. The issue of the reference were purportedly raised at the instance of the workman. The workman did not raise any demand or grievance before the management. The dispute purported one and is also a stale and belated one, and is barred by letter. The reference is also bad in law and also on facts. To continue a reference of a industrial dispute is in accord with to observe a certain formalities and mandatory conditions, but neither prescribed formalities were observed, nor were the mandatory conditions fulfilled filled up. Before referring the dispute for adjudication, the appropriate government must give an opportunity to the management to explain their matter, but it was not done in this case. At all the stages of reference, the principle of natural justice must be observed, and the failure of the government to do that, so found in this case, has caused serious prejudice to the management, and and this makes the reference illegal. The industrial tribunal has no inherent power or otherwise to adjudicate alleged purported dispute. Kachar Chak Karmik Sangha is not a recognized union in their garden, and as such, they have no authority to espouse any dispute for or on behalf of the workmen of the garden. The concerned workman, Sri Joy Narayan Kohli, had been working as a permanent worker of Lalamukh Tea Estate, Hailakandi, since 4/8/2019, 2009, it could be Lordship, and also a permanent laborer of the garden. And being a laborer of the garden, he was required to do all sorts of work as the garden of the garden, as and when allotted to him. The concerned workman resides in a house near the garden at the Kunkumi Basti, about 1.5 kilometers from Lalamukh Tea Estate, and he has also a paddy land and a gosala at his village. His father, Prasad Kohli, was a permanent laborer of the garden, and after his retirement, he was re-employed in the state garden and was allotted a job as chowkidar of the Swiss Gate, which is situated at a distance of 100 meters from his residence at Kunkum Basti, considering his ailing health. After the release of the father from the chowkidarship of the Swiss Gate, another permanent worker of the garden was also posted in the said duty. The concerned workman had been working at that plantation of the garden, but for some time past, he was grumbling for allotting a job of chowkidar at Swiss Gate aforesaid. He had remained unauthorizedly absent and did not report for duty since 29/11/2003 and was served with a warning notice for his unauthorized absence, but he refused to accept the same. He, being the permanent workman of the garden, is free to join his work at the plantation of the garden. The management has neither stopped him from attending his duties nor dismissed him from service as alleged by him in his written statement. All the averments made in the written statement by him are not true. The management reserves the right to file additional evidence. By filing the written statement, the concerned workman, Sri Joyram Koiri, states that he had been working as permanent laborer since 1996, but suddenly the garden authorities dismissed him from service on 29/11/2003 and stopped him to work there due to personal grudge and without showing any reason. And in doing so, the garden authority never served on him any show cause notice. On 16/12/2003, he on 16/12/2003 placed one representation on the management of the garden, praying to reinstate him in service of the garden, as he had no means of livelihood, but due to non-action of the garden authority, approached the labor office of Hailakandi for redressal of his grievances, and accordingly, the letter called a joint inquiry cum discussion in his office on 27/1/2004, but the management neither attended the said meeting on the day nor attended subsequent meetings called by him with an intention to delay the matter. The labor officer of Hailakandi initiated a conciliation proceeding on 14/7/2004, but the management side did not attend on any date in the conciliation proceeding, and in result, the conciliation proceeding failed. He was quite surprised finding that the management side submitted 3 warning notices dated this before the labor office, Hailakandi, showing that he had been given warning on 3 occasions for being absent from work. But in reality, he never received such notices from the Guardian Authority. He also approached the Labor Commissioner, Assam, for redressal of his grievances, and the letter also talked with the Labor Officer Hailakandi over phone and on the matter, and also sent a letter to the Labor Officer to do the needful for doing justice to him. He was surprised by receiving a copy of the letter of the Labor Officer Hailakandi on 8/9/2004, addressed to the Labor Commissioner, stating that the inter alia the management had agreed to offer him work, but he himself denied joining from duty. From the letter, it transpired that the labor officer believed the version of the manager of the garden after giving assurance by the labor commissioner, Assam, and the labor officer, Haila Gandhi. He approached the management of the said garden for work, but the management refused to allow him to work in the garden. Again, on 23/5/2005, he filed a representation before the labor commissioner, Assam, praying for issuing direction to the manager to allow him to work in the garden as he was very poor man having family and presently having no means of livelihood. But the labor commissioner refused to act upon his representation, this time as the matter had been referred to the industrial tribunal. The management dismissed him from service without show cause notice and without giving him any chance to explain, and therefore dismissing him from services in attending the work by the management is not justified, and the act of the management amounts to deprivation of his right to life and livelihood as guaranteed under Article 21 of the Constitution. Hence, the management is liable to be directed to set aside and quash the notices dated this, and reinstate him and allow him to work in the garden in the same capacity with back pages, cancelling the dismissal order. I have perused the submission of the learned counsel on both the parties as well as their pleading. I have also perused the evidence adduced by the parties. The learned counsel of the union side, learned advocate K. Datta Chaudhary, submitted that the management had illegally and arbitrarily dismissed the concerned workmen from service in the Lalamukh Tea State and also illegally stopped him in attending his duties in the said garden, while the counsel for the management, learned this, submits that in no case of it is not a case of dismissal or stopping in joining duty. It's a clear case of abandoning the service by the workman, as the concerned workman, namely this, willfully abandoned his service in Lalamukh District. The first plea of the management is that the government had not given the management opportunity of hearing before sending the reference, and hence the reference is illegal. It is seen that the Assistant Labor Commissioner had called upon the conciliation meeting, first on this and second on this. The union side states that in both the days days of the conciliation proceeding, the management was absent, although notice was served on them. The management is not denying that the notices of conciliation proceeding that this were served on them. Thus, it's proved that the notice of the conciliation proceedings was served on the management, but they intentionally made themselves absent in the said proceeding. It is found that for their failure to attend the conciliation proceeding, the same yield no positive result. It is seen that when the conciliation had failed, the government by this had sent the case to the tribunal for adjudication. So it cannot be said that the government referred the dispute to the tribunal without giving the management the opportunity of hearing. The workman side is that Joyram Kori had been permanent labor at Lalamukh Tea Estate, where he had been working since 1996, but the Garden Authority dismissed him from service on 29/11/2003 and stopped him from to work on the personal grudge without showing reason. He on this filed an application to the management for reinstatement. The management side's plea is that the father of the workman, namely Prasad Kori, was re-employed after his retirement and was posted as Chokidar in the Free State, and after his release from the re-employment, on one permanent worker was assigned with his duty, while Joyram Koli was working in the plantation sector. He was for some past time grumbling about the allotment of the job of Chokidar in the Free State aforesaid and remained absent unauthorizedly from duty since 29/11/2003 and was served with warning notices of his unauthorized absence. But he refused to accept, but the management never dismissed him nor stopped him from service, but the management side advocate argues that it was a case of willful abandonment of service and the workman willfully abandoned his service. Rebutting the submissions of the learned advocate, the advocate for the workman submitted that it is a case of dismissal without showing cause, and that the management had no pleading that the workman abandoned the service, but the management in the written statement clearly pleads that the workman had been unauthorizedly absent from 29/11/2003. Hence, in such a situation, the management cannot be allowed to take a new plea, that is, the workman abandoned the service in the management's estate. The learned advocate Datta further submits that no warning notices were served upon the management as stated by management, and the so-called notices were fabricated. One thing is clear from the case record that the management had not held any domestic inquiry against the workmen, framing charges against the workmen of unauthorized action. While the management themselves in their pleading state that the workmen had been unauthorizedly absent since 29/11/2003, without pleading, he abandoned his services. It is the bounden duty of the management to hold domestic inquiry against the workmen for framing charges of unauthorized absence, but they willfully abstain from holding such inquiry. Before entering into the factual metrics, then he quotes the Supreme Court judgment. Now, it is settled law that if an employer wants to prove a case of voluntary abandonment of service by the workman, they have to serve a notice upon him and asking him to resume duties, and yet he did not resume his duties. And if the employer fails to do so, it cannot be held that the workman voluntarily abandoned the service unless the employee workman admits that he had voluntarily admitted service. The management side submits that the notices were served, calling him to resume his duty, but he did not turn up. While the counsel for the workmen submits that no notices were served upon the work. Exhibit A, B, C are fabricated. Management witness number 1, Motilal Dhar, in his evidence stated that 3 warning notices of unauthorized absence of the workmen in duty were served on the workmen through their workmen Uttam Dhubi and Kamal Ghosh since deceased, but he refused to accept the same. M1 further states that Exhibit A, B, C are the said notices. I have perused Exhibit A, B, C and found that Exhibit A is a notice prepared to be sent to the workman warning him for remaining absent unauthorizedly from 29/11/2003 to 2012/2003. Exhibit B, warning notice to the workman for remaining absent unauthorizedly from 29/11 to 2012/2003, and Exhibit C for remaining absent from 2012/2003 to 19/8/2004. In each notices, there is a note in ink, notice Grohan Korine, which in Bengali, which were written by the same person. In these notices, in these notices were no note to the effect that the notices were delivered to him after finding him in his house or elsewhere, but he refused to accept. The notices bear no note as to whose presence the notices were delivered to the workman or who were present when the workman refused to accept the notice. Thus, it is found that there is no supporting evidence to the fact of trying to serve notices upon the workman, and he actually refused to accept those notices. In such a situation, the notices Grohan Korini, which is found in Exhibit A, B, and C, is not to be believed. Secondly, it is found that the said notices were written by the same person, the same ink, and probably in the same day. MW2 states that he himself brought Exhibit A and B to the workman and delivered it to those to him. And when he refused to accept, then he read out the contents of those notices to him and returned to the office, and late Kumud Ghosh brought Exhibit AC to the workman, and when he declined to accept the notice, Kumud Ghosh read out the contents to him, returned to the office. This version of PW2 cannot be believed because he had not brought any third-party witness of the alleged fact of processor. Likewise, Date Kumud Ghosh also has not brought any third-party witness to allege to witness the alleged fact of process served. The management also adduced no evidence to support the version of M2 as well as M1, and the evidence of M2 and M1 cannot be relied on as they are interested witnesses, having both were employees of the garden. M2 is the cross-examined states that A, B, C, A1, B1, and C1 were written by the head clerk A after they handed the notice of the workman. He also stated that he had not accompanied Date Ghosh while he went to the residence of this to deliver Exhibit C. Thus, it proves that Exhibit A1, B1, C1 notes were written by the head clerk of the garden, Onup Dey, in his office on the same day as those were not reports of Uttam Dubi and late Kumud Ghosh. So this proves that Exhibit A, B, C were prepared by and fabricated documents. Thirdly, even if it's supposed that these are genuine documents, then also we find that Exhibit A1, B1, and C1, the notes notice Grohan Koriti do not prove the fact of the visiting of the residence of the workmen to serve the notices and deliver this. And he refuses to accept the notice. A notice having no independent witness to come to support of that. Now, Lordship, in this, the labor industrial presiding officer says that these people are interested witness. Obviously, Lordship, the employee of the garden will go and they'll come and depose. Where's the question of independent witness? And no notice, Lordship, is served by taking witness. It's not the case. They go serve, they come report the office, and it's written there. So this presumption is absolutely biased and it's all presumptions. That is opinion of the thing, not based on facts. From the above discussion, I'm of the opinion that the working notices dated this were not brought to the workman and handed over to him, and hence the question of refusing to accept does not arise. And those are documents are fabricated by the management in the later stage to save themselves from the case. Thus, I hold that no notice of calling the workman to join duty was sent to him. This lacking of the part of the management falsifies the pleading of the management, and the workman has abandoned his service. In this case, the workman states in evidence that one Dudnath, an employee of Lalamukh District, has lodged a complaint against YTR case number this against his brother, and in that case, one Radhesham Ravidas deposed in evidence that where Radhesham Ravidas clearly stated that he, workman Joynath Kormi, had been stopped from working with effect from 29/11/2003. Further, that the Exhibit R is the copy of the statement of Radhesham Ravidas in CR 434 of the Exhibit R is not refuted by the management side, nor questioned the genuineness of the of his content. Hence, the contents of Exhibit R can be accepted as evidence in this case, and thus the statement of Ravidas in CR case number this of the Court of Judicial Magistrate that the workman has been stopped by the management from work with effect from tonight can be taken to be a corroborative evidence to the statement of the workman. So I hold that the statement of the workman that he was stopped from service by the management with effect from 29/11/2003 without showing cause is believable. Now, Rostic, this is in another proceeding, a statement of one of the witnesses. This witness was not called by the workman to give evidence on his behalf. You just bring a case from somewhere and that cannot be accepted as evidence, corroborating the evidence of the manager. He may have given that statement, but they could have called the witness. That was not done. Just a statement has been produced before the court, and the labor court accepts. The workman in his evidence further states that after stopping him to work, he on 16/12 lodged one representation with the management, and the management side has received the said representation. Exhibit Q is the photo set copy of the representation with acknowledgement card. The management side had not rebutted the said document, Hence, Q is presumed to be genuine document and its content to be true. From Exhibit Q, it's seen that the workman, by letter dated this, prayed to the management to reinstate him and was received by the manager of the garden. Since Q supports the plea of the workman, after his dismissal, he on 16/12/2004 filed representation to the management praying for to reinstate him, but the management did not act upon the prayer. The factual situation is clearly shows that the workman had not abandoned his duty, but he had been stopped, dismissed from service. The learned advocate, Mr. Strom, argues that in cross-examination, the workman, by stating it is the fact that the management has not given me has given me work in the other place, but I did not accept it. Admits that the management had given work to him in other place, but he did not accept. Hence, this admission amounts to abandonment of service by the workman. But there is another implication of this type of suggestion that the management had given work on other place, but you did not accept it, which that is the case of dismissal, and hence the management, after realizing their fault, tried to reinstate the workman in another post. This fact supports the plea of the workman. It's settled principle that dismissing a workman who was illegally dismissed from service, he has right not to be forced to join job in another post, but to join job from the post where he was dismissed. Therefore, the workman was actually offered another job, but he refused to join the job, which then also it cannot be said that the workman abandoned his service. Refusing to join another post there's no way extinguish the right of the workman to be reinstated in the post from which he was dismissed. Thus, I hold that the alleged admission on the part of the workman does not prove the plea of the management. Rather, it proves that the plea of the workman that he was dismissed with effect from this by the management without show cause. Then now lordship here also. Another post he was given, workman, they are given this job here today in the factory, today in the garden. So that is not another post. It's not a cadre or something that you transferred. It's just an summing up the discussion. I hold clearly established that the workman was stopped, dismissed from service by the management with effect from 29/11/2003 without showing cause. And I hold the workman was dismissed from service by the management on 29/11/2003 without showing cause. It's found that the management terminated the workman without complying with the provisions of 25F of the Industrial Disputes Act. Now, it's settled principle of law that termination of workmen by the management without complying with the provisions of 25F of the Industrial Disputes Act, and such termination illegal, and the workman is entitled to be reinstated. So I hold that the management is not justified in dismissing Topping Jairam from service with effect from 29/11/2003 and is entitled to be reinstated. It is found that the management never issued absentee notice to the workman. Hence, the question of justification of issuing absentee notice does not arise. Next question is whether the workman is entitled to back wage. The workman in his pleading says that he is, after his dismissal from service, he has no means of livelihood. The management has no pleadings as to whether the workman has any means of livelihood. In the cross-examination, workman says that he has no cultivation, no other cow or bullock. The management side has found not adducing any evidence to show that the workman is employed and gainfully employed. Thus, it seems that the management failed to prove that the workman is presently employed and gainfully employed. It is a settled principle of law when the dismissed workman states that he has no means of livelihood, then the burden shifts to the management to prove that the workman is employed after dismissal and it is also gainfully employed. This burden is not disclosed by the management, is not discharged by the management, hence the workman what the workman stated must be true. In this, observe that full back wages are no longer natural corollary of an order reinstatement. Rather, grant and quantum of back wages would depend upon several factors, and the court has to weigh the pros and cons of each case and take a pragmatic view. Being guided by the principle laid down by the Supreme Court as above, I am of the opinion the tribunal has the discretion to look into some circumstances in taking a decision in granting back wages. From the record, it's seen that presently the workman is a man of 42 years of age, and on day of dismissal, he was a man of 32 years of age, and an able-bodied man having family in the rural area where the demand for unskilled labor is high. So it must be judged that after dismissal, he might have been earning some income either by working as an agricultural labor or a construction worker. His version is that he is presently he has no livelihood. Is not absolutely true, but it's true that he is presently employed, but may not be gainfully employed. Therefore, I'm the opinion is entitled to 50% of the back wages. Because of what has been said above, I hold that the management is not justifying in stopping and dismissing the workman from his service with effect from 29/11, and hence is entitled to reinstatement to the post from where he had been dismissed with 50% back pay. That's what he has said. Now, this is all on premises and surmises that the court has come to the finding that notices were not served. He wants the person who went to serve the notice did not take any witness with him, and the notices were written later on at the head office. These are all presumptions and they're fabricated. There's no basis for that. And to call the management witness, interested witness also is quite preposterous, because it's the employee of the management who would go to serve the notice, and they will come and give evidence. As far as the workman being not employed, Lordship, except his statement, there's nothing. He has not filed an affidavit to the fact that he has not been employed till the date of hearing. But at present, there's no affidavit even before this court stating that he's not employed. And if that is the case, it has to be proved, Lordship. Supreme Court has held clearly that the burden is on the workman to state that he is not employed. He is not employed. And once he states that, then the management can rebut. So in my respectful submission, Lordship, since I've never dismissed him, and now he has come back to my garden, he is not entitled to he can continue working, but he's not entitled to back.
Just two, three clarifications. Is there any interim order passed in these proceedings?
Yes, Lordship, there was the order.
The impugned award, insofar as the payment of back wages shall remain suspended,
Yes.
subject to payment of 25,000. You have paid before the registry, 25,000.
Yes.
Okay, and this order, the stay order was only operative so far as back wages were concerned.
Yes, because our stand is that we didn't dismiss him. He's most welcome to work.
Okay, just a minute, 24 to. Order of 24 to 2014.
Yes.
Rule. Okay. Where in your written statement have you stated that he was free to join? He was never dismissed.
That is been a consistent stand. No, these are the evidence. The witness statement. I don't think I missed this. That's it. Written statement by the by the management is that page 18. I'll just,
You come to page 20, paragraph 10, towards the
Yes.
last part.
yes, sir. We said that Chitwaram was a permanent worker on
Paragraph
Lalamove
10.
Tea Estate, and the management of Lalamove Tea Estate has neither stopped Joyram Kohli from attending his duties nor dismissed him from his service of Tea Estate as alleged in the written statement. All these averment statements made by the union in the written statement are not true, and the union are required to strict proof thereof. That's what we said.
Okay. Number 2, the learned tribunal has referred and relied upon a statement of one Radheshyam,
Yes,
which he has made in another proceeding,
made another.
which is exhibited as Exhibit R.
Yes,
That there is no bar for relying upon a statement. But you said that Radheshyam was not produced as a witness.
was not produced as a witness.
You have to support your submission by case laws. That pre-recorded statement can be relied upon, but before relying, you have to give the other side an opportunity to cross-examine.
Yes, Lord.
Have you got any case law?
I don't have a case law, but that's an accepted fact, Lordship.
No, it's in the court proceeding.
Yes, in a court proceeding.
It's not a 161 statement.
It's not a 161
So,
but it was a court proceeding
court
in
proceeding-
another case.
So there is some kind of sanctity.
It was his statements, not the finding of the court.
No, but the statement of the this Pradesam
Yes, Lord.
was produced as Exhibit R, which also contains some cross-examination. It is not something 161 kind of, it's kind of a 160, it's more than that, it's in a court
It's
proceeding.
a court proceeding. It's a
But
complaint.
even then,
It was a
even
complaint.
then, since he is relying upon that statement in a different case, without giving you an opportunity to cross-examine that person by producing him,
Yes,
that will not be proper.
That will not be
On that line, do you have any case laws?
I as of now, right now, I don't have the case, but I can give it to you. Lord. That would because Radhesham has to produce, he could have come here. And I do not see in another complaint case, in different circumstances, a statement is made, and that's not a finding of the court. Doctor. Had
Yeah,
he-
the court's finding is that management did not question the genuineness and the contents.
Yes,
That is the finding at page 34.
yes, Doctor, that's what the court said. That's what the court said. Because Radhesham was not there, even if the content is correct, we do not know whether the statement is true or false. That has to be tested. Had Radhesham been here, I could have tested. One can make any statement of. And if he has, and if the workman had made a specific statement, very specific statement is cross-examined. I had given.
Now,
one-
what would be the period of his, from the records, we have gathered that on 4/8/1999,
He abandoned.
he was inducted in the service.
Yeah.
4/8/1999.
Yeah.
And he stopped coming with, and then you had dismissed him, or his allegation of dismissal is from 29/11/2003.
3.
And as per you, from when did he stop coming?
From 29/11/2003.
From that date, 29/11/2003. So the direction for payment of back wages would be from 29/11/2003.
Yes, sir.
And this, in this proceedings, rule was issued in 2014.
Right.
And even thereafter, he did not join.
No. He never joined.
He has joined, come to and offered his service only after the last order.
After your lordship.
And you have allowed him to.
We have allowed.
When was what is the date?
It was 20th December 2023.
2012.
2012. 2012. He came and he's working.
Yes, Mrs. Sinha. Anything else, madam?
Okay.
Anything else?
No, that's all.
Okay, we'll come back to you. Let us hear Mrs. Sinha. Okay, Mrs. Sinha.
Lordship, in this case, Lordship, the workman was wrongly stopped from attending and doing his work by the management. By the Lordship, repeated approach to labor officer and the labor commissioner also, Lordship, the management did not allow him to work. And Lordship, even after the judgment of the Lordship, order of the tribunal, he approached the management, but he has not.
Where have you stated? See, this court, while issuing rule in the year 2014, had made it clear that the interim order pertains only to the part of the judgment connected with payment of 50% back wages. There was no restraint on the other part. And in fact, the consistent stand of the management is that you are never dismissed or disallowed. We have seen the written statement that you are always, since you wanted to work in a different place, from your own volition, you have stopped coming to the garden. That is their stand. We have not accepted till now, but after that, if you say that from 2014 till the last 20th of December, you are still out.
14, Lordship, he has not approached after Lordship, after this
That the conduct will be very much
But
against you.
Lordship, because Lordship, before filing of this writ petition, immediately after getting the tribunal's order, he approached the management, but he said, Lordship, they have already preferred appeal, wait for the Lordship outcome of the order of the High Court.
You have to have some,
After he has not approached.
you have to have some pleadings. In absence of pleadings, we cannot wear a read court. We'll go by the records.
Lordship, so in the Lordship, I'm only praying for back wages from 2003 to till the date of the Lordship order of the tribunal, Lordship.
Now, that is the part of challenge. At least you should have in your evidence. Where is your evidence?
In a written statement, Lordship.
No, not written statement. Evidence. Written statement, we have seen your written statement.
Lord.
See, back wages is not something automatic. Back wages, you have to show that you are forcefully disallowed not to from discharging your duties. If you choose not to go and then claim for back wages, that will not be justified. And it is not a case of dismissal. That dismissal has been set aside, though then thereafter we need to decide on how much back wages, if any, will be allowed. It's not a case of dismissal. Labor court tribunal has come to a finding. There was no domestic inquiry. There is no proceeding to dismiss you. Though the reference has been structured by using the word dismissal / stopped you from coming, the part of dismissal is never there. Under those circumstances, to have an order retained for payment of back wages, the burden is very much upon you, and it's a heavy burden to discharge. More so when you have your conduct is not very inspiring. 2014 to 2023, you have not filed an affidavit stating that you had gone there, not allowed. For 10 years, you chose to not to do anything. And now, even if now, after this order, you would have said, no, I had gone again, not allowed. You are also admitting that on 2012, 2023, when you had gone there to report, you were allowed to work. Under those circumstances, it will be difficult. Reinstatement or joining back, there is no difficulty. In fact, they are not even objecting. Senior counsel has said that let him come. There are only grievances against the part of back wages, which is also the subject matter of the interim order. How much is your wage at that time?
That time lordship, 42.
Hmm?
At the time of passing of the judgment lordship, he was 42.
No.
At the time of dismissal.
Wage, not age.
Oh, wait, I have no,
Madam, will interfere with the back wage, but pay him some lump sum amount.
Lordship, I'll just,
You must have already thought about that.
no, his examination, cross-examination.
Huh? Yes.
He clearly says that the fact that the management has given me work in other place, but I did not except in my father's place. Prior to 2003, I was working for 10 years in the garden. While my father was working in the garden, I was also working. It's a fact that I was given employment by the garden in other place, but I did not accept. Then again, he says, I am not willing to work in the factory if the management allows. So this is the clear stand of the workman in his exam.
Pay him some lump sum amount. Living is very difficult nowadays. Cost of living, some lump sum amount.
But if he was employed,
We'll accept your arguments.
how much? If
Minimal amount will quantify.
I think it's better to come from your lordship.
No, you say, no, we'll not say it's your, you have suggested.
I really do not know how much he is entitled to as back wages. for
No,
10
even
years.
if you say 4,000, even minimal 4,000, in 1 year, how much?
48,000,
48,000. 10 years,
4 lakh 80,000.
4 lakhs. We'll have 50% of 4 lakh, 2 lakh something. We'll ask some minimal amount. 25 was already paid.
Another
Yeah.
25 plus.
Okay, we'll consider.
Okay.
We'll pass the judgment right now.
Okay.
Have a seat, Mr. Pure, বিপ্লব আহিছিল pure. এফাল দিয়ে পৰি বলে। বিপ্লব ক'ত গ'ল? এফাল দিয়ে আহিব দিয়ে। কিয় গুচি গ'ল আৰু? The legality and validity of an award dated 25/2/2013 passed by the learned Industrial Tribunal Silchar in reference case number 2 of 2005 is the subject matter of challenge, full stop, by the aforesaid award, comma, the learned tribunal has held that the management was not justified in stopping, dismissing the workman from his service with effect from 29/11/2013 3 and was accordingly directed to be reinstated with 50% back wages. Full stop. Para. This court, while issuing rule wide order dated 24/2/2014, had, however, passed an interim order so far as the direction regarding back wages were concerned. Full stop. Para. Before going to the issue which has arisen for determination, the basic facts of the case can be narrated in brief in the following manner. Full stop. The aforesaid reference was made to the learned tribunal on the following issues, page 24, ABC. Para. Both the management, both the petitioner dash management and the workman dash respondent had filed their written statement. Full stop. The management had adduced evidence through 3 numbers of witnesses. How many witnesses, madam? 3 numbers of witnesses, whereas the workman had adduced evidence through himself. Full stop. Para. According to the written statement, according to the version projected by the workman, he was not allowed to perform his duties from 29/11/2003 without any reason, and his approach to the management had also failed to yield any positive results. Full stop. It is also projected that there was no proceeding or any allegation against the workman, against him. Full stop. As regards 3 numbers of notices which were also placed on record at the time of conciliation, the workman had stated that those notices which were exhibited as Exhibit A, B, and C were never served upon him. Full stop. The workman had also relied upon the statement of one Radhesam, which was made in connection with another case and was exhibited as Exhibit R. Full stop. The said person, Radhesham, had stated that the workman was not allowed to work in the garden. Full stop. The aforesaid Exhibit R was accepted by the learned tribunal. Full stop. In paragraph 8 of the written statement, the workman has said that he did not have any means of livelihood. Full stop. Para. The petitioner management, in their written statement, has, however, refuted all the facts projected, full stop. In paragraph 10 of the said written statement, comma, it has been clearly stated that the management never stopped the workman from discharging his duties, and the workman had stopped coming for his duties on his own volition, full stop. It has further been explained that the workman wanted the job of a particular nature, namely to maintain the sluice gate, which job was earlier given to his father, and the sluice gate was nearer to his home. Full stop. Para. The learned tribunal, after hearing the parties, have, however, has, however, accepted the plea of the workman and has directed his reinstatement with payment of back wages of 50%, which has been stated above. Full stop. Para. I have heard MSM Hazarika, Learned Senior Counsel for the petitioner management, assisted by Sri D. Khan. Full stop. I have also heard Sri S. K. Sinha, Learned Counsel for the respondent number 4. Chetia for anybody? Sri M. Chetia, Learned State Council, is present for the, is also present. Full stop. Para. Ms. Hazarika, the Learned Senior Counsel for the petitioner, has submitted that the findings arrived at by the learned tribunal is not based on the materials on record and is rather based on surmises and conjectures. Full stop. It is submitted that all the 3 notices dated ... were served, were tendered to the workman, which was received to be received, and those notices have been duly proved as exhibit A, B, and C by a competent witness. Full stop. It is submitted that the tribunal took a hyper-technical approach in seeking any independent witness as independent witness, full stop. It is submitted that notices of the management cannot be served by any independent witness, and therefore the question of those witnesses being interested in witness would not arise. Full stop. With regard to the exhibit R, which is the statement of one Radheshyam, comma, it is submitted that though there may not be any legal bar in accepting a pre-recorded statement, comma, it is the requirement of law that the maker of such statement is required to be produced in the proceedings so as to give the other party a scope to cross-examine. And without such cross-examination, comma, such statements cannot be accepted. Full stop. The reference has also been made to the cross-examination of the workman, wherein he has accepted that he had wanted to work in a particular location, namely the sluice gate of the garden as a chowkidar. Full stop. Para. The Learned Senior Council has also submitted that though rule was issued on 24/2/2024, and the interim order was only confined to the direction for payment of back wages, and there was no restraint on the direction for the petitioner, for the workman to join in his service, the workman never came to join in his service, full stop. It has been submitted further that it is only after the order dated 12/12/2023 passed by this court on the last date of hearing that the workman had reported for his service on 20/12/2023, and he was accordingly allowed to discharge his duties. Full stop. It is submitted that till date, there is no affidavit filed by the workman in the writ petition which gives rise to a presumption that the projection made by the petitioner would be correct, is correct. Full stop. The Learned Senior Council accordingly submits that though the management would not have a serious difficulty in the issue of reinstatement of the petitioner, which has already been done, the challenge is mainly with regard to the direction for payment of 50% back wages, which has been quantified as 50% by the Learned Tribunal. Full stop. Para. Sri Sinha, the Learned Council for the response number 4 has, however, submitted that from 29/11/2003, the workman was not allowed to permit his duties. Full stop. He submits that since the duties, since there will be no difference in performing the duties either in the garden or in the sluice gate, the workman should have been allowed to perform his duties as chowkidar manning the sluice gate. Full stop. The receipt of the 3 numbers of notices have been denied, both in the conciliation as well as before the Learned Tribunal by way of filing of the written statement. Full stop. The Learned Council for the workman has, however, fairly accepted that till now, no affidavit has been filed in these proceedings. Full stop. He has also accepted that so far as Exhibit R is concerned, comma, the maker of the statement, one Radheshyam, was not produced as a witness. Full stop. However, at the same breath, comma, he submits that the statements was made in another court proceedings and therefore there would be a sanctity attached to the said statement and therefore can be accepted. Full stop. Para. The rival submissions made by the learned counsel for the parties have been duly considered, and the records of the learned tribunal which have been transmitted have been examined. Full stop. Para. At the outset, comma, though the reference was structured by using the expression of dismissal of the workman, comma, this court, upon perusal of the materials, is of the view that the case was not involving any dismissal from service and was rather from the allegation made by the workman that he was stopped from discharging his duties. Full stop. It is right law that dismissal, the expression dismissal has to be preceded by a procedure established in law, whereby the affected party, public delinquent employee, is required to be given an opportunity of defending himself. Full stop. However, comma, in the instant case, comma, this court has observed that the management had never pleaded that they had dismissed the workman from service, and rather, according to the management, comma, he was always offered to come for his duties, which on his own volition, comma, the workman had refused. Full stop. The materials on record would also suggest that since the father of the workman was allotted duties of manning the sluice gate of the garden, comma, the petitioner, the workman who was in service with the garden, wanted to have the same job. Full stop. It also transpires that after the discontinuation of service of the father of the workman on his superannuation, comma, the aforesaid job of manning the sluice gate was given to another person. Full stop. The discretion of the management to utilize the service of a workman who was a daily wager, who was a daily rated worker, cannot be embarked upon unless except in exceptional circumstances, wherein a case of victimization can be established. Full stop. However, in the instant case, there is no such allegation. Full stop. Para. With regard to the findings of the learned tribunal, for not accepting exhibits A, B, and C, which are notices, comma, this court is not inclined to accept the said findings barely on the fact that tendering of the three notices were not proved by any independent witness. Full stop. As regards the exhibit R, comma, this court is of the view that though there may not be any legal embargo to rely upon a pre-recorded statement, comma, it is straight law that the maker of such statement has to be produced in the proceedings, and the other side be given a chance to cross-examine so as to maintain fairness and transparency, which does not appear to have been done in the instant case. Full stop. The findings of the learned tribunal that the management did not question the genuineness of the said exhibit R would be of no consequence, as admittedly, comma, the maker, one Sri Radheshyam, was not produced as a witness before the learned tribunal. Full stop. Para. With regard to the means of livelihood, which is directly connected with the direction for payment of back wages, comma, though a statement has been made in paragraph 8 of the written statement by the workman that he did not have any means of livelihood, comma, such statement has to be examined with the attending facts and circumstances, comma. The consistent stand of the management is that the workman was never stopped from discharging his duties, and he on his own volition had stopped from coming to attend his duties. Full stop. Sri Sinha, the learned counsel, had tried to argue that even after the order of this court dated 24/2/2014, comma, the petitioner, the workman was not allowed to perform his duties, full stop. However, comma, in absence of an affidavit in this regard, comma, such statement orally made cannot be accepted. More so when this court has been apprised that after the last order passed by this court on 20/12/2023, when the workman had reported for his duties, comma, he has been allowed to join, and this fact has been accepted by the learned counsel for the workman. Full stop. Under those circumstances, comma, this court is of the opinion that while the issue of reinstatement may not require any interference, as it was never a case of dismissal, comma, the direction for payment of back wages does not appear to be reasonable and based on the attending facts and circumstances. Full stop. Accordingly, the impugned award dated 25/5/2013 passed by the learned Industrial Tribunal, Silchar, in reference case number 2 of 2005 stands interfered with so far as payment of back wages is concerned, full stop. This court, however, makes it clear that since the workman has already reported for his duties on 2012-2023, the management should facilitate him from performing his duties in accordance with law, full stop. Though the part of the award concerning payment of back wages has been interfered with, considering the facts and circumstances, this court is inclined to pass a direction for payment of a lump sum amount to the workman. So stop. This court has noticed that while issuing rule wide order dated 24/2/2014, an amount of rupees 25,000 was directed to be paid, which was accordingly done, full stop para. In the interest of justice, this court directs the management to pay another amount of rupees 50,000 to the workman, which is required to be done within a period of 2 months from today. Full stop. The petition accordingly stands disposed of. The original records be transmitted back forthwith.
Okay.
Lordship, I beg your apologies, Lordship, actually. Lordship, some more time. We have been trying to get in touch with the petition.
No, we are dismissing this. We had granted time on the earlier occasion.
Lordship,
It become infructuous.
we're trying to get in touch, but getting it. One chance,
No. It's a 2014 matter.
that is,
We had given you a chance earlier. Earlier it was listed on 9/11/2023. You have tried your best.
yes, Lordship,
Your
no,
No,
on behalf of him,
what is your name?
NJ Chaudhary.
Your NJ Chaudhary. Sri NJ Chaudhary. No. This court on the last occasion had passed the following order. 9/11 Port Kodiba. Para. Sri NJ Chaudhary, Learned Counsel, submits that in spite of his best efforts, no instructions could be obtained from his client. Full stop. Para. Also heard Sri G. Bukolial, Learned State Counsel, who by referring to the last order dated 9/11/2023 has submitted that this court has already observed that the writ petition had, in all probability, has become infructuous, full stop para. In view of the above, without expressing any opinion on the merits, this writ petition is dismissed for want of prosecution. Item 4. Yes.
But look, this is a case of dismissal of 12 workmen.
Another labor code matter.
Yes, Lord. Lord, what happened in this case, Lord, a preliminary issue was framed about the fairness of the inquiry. And the learned presiding officer was of the view that the inquiry was fair. Thereafter, my lord, he, by this same order award, he held that so far the dismissal are concerned, it is justified. He has not exercised his power under 11A. That your lordship would find at page 22. Before going to that aspect, my lord.
Twenty-two.
Page 22 straightway.
Yes.
Before going to the marrying, Lord, I just illegal.
But Mr. Rajgupta, we're just trying to extract from you. If the fairness of the domestic inquiry is put to question before a tribunal or a labor court, and the tribunal or labor court decides in favor of the management, then is there any requirement to go for a further inquiry? Firestone says that there is no requirement.
No,
You will go for a further inquiry when you come to a finding that it was not fair.
no.
If
No.
the findings are in favor of the management, that it is fair,
Uh,
then
then he has
he
to accept.
can apply his discretion under 11A regarding
Yes. That's
the proportionality.
Yes.
But there is no requirement to go again to another inquiry.
No. That
Because
is not.
Firestone has made.
No,
very
yes.
clear.
That is 100% correct. No, that is the point that I would like to place before your lordship. That on to page 22, bottom portion, Lord. Before going to the marriage of this case, Lord.
Okay. Yes, please.
Under this circumstance,
Yes, please. Under the circumstances.
under the circumstances, I have found that the preliminary issue is decided accordingly in favor of the management, that they followed the principles of natural justice in dismissing the workman. Okay. As a result of that, I can give answer to the issues framed that the management is justified 12 number of workers by such and such for dismissal. All right, this is the number. Therefore, I feel that they have entitled no order of their reinstatement with full back wages. Now, where the mistake that has been committed, that is, I would like to point it out. If it is, this is the very much. It is found in this regard that Indian Iron Steel Company Limited, that is AIR 1958, page 130, following grounds and circumstances interpret which are as follows. Now, my lord, if your lordship goes through, this is the case for which the section 11A was inserted. Now, my lord, I'm passing this judgment, my lord, your lord.
I did in this filter, this filter.
This is the case, my lord. Straightway, there is a Firestone's case, my lord.
Yes.
Straightway, you'll have to come to paragraph 3. May I read, my lord?
Just a minute.
Firestone petitioner, 1973, 1 SSC, page 813.
Yes, yes.
Now, statement and object. In Indian Iron and Steel Company Limited,
Paragraph?
Huh?
Paragraph?
Paragraph 3.
Oh, you're referring to Firestone?
First.
Okay.
Regarding section 11A, the statement of object and reason, it is stated as follows. in Indian Iron and Steel Company Limited and another versus their workmen, 1958, page 130. This is the case that has been referred by the learned presiding officer at page 22.
Correct.
So this case laid to insert section 11A. The Supreme Court, while considering the tribunal's power to interfere with the management's decision to dismiss, discharge, or terminate the services of a workman, has observed that in case of dismissal or dismissal of on misconduct, the tribunal does not act as a court of appeal and substitutes its own judgment for that of the management, and the tribunal will interfere only when there is want of good faith, victimization, unfair labor practice, etc., on the part of the management. Now, look. The International Labour Court Organization, in its recommendation number 119 concerning termination of employment at the initiative of the employer, adopted in June 1963, has recommended that a worker aggrieved by the termination of his employment should be entitled to appeal against the termination, among others, to a neutral body such as arbitrator, a court or court and arbitration committee, or a similar body, and that of neutral body concerned should be empowered to examine the reasons given in the termination of employment and the other circumstances relating to the case, and to render decisions on the justification of the termination. The International Labour Organization has further recommended that neutral body should be empowered if it finds that the termination of employment was unjustified. Employment was unjustified. To order that the worker concerned, unless reinstated with unpaid wages, should be paid adequate compensation to afforded some other relief. In accordance with these recommendations, it is considered that the tribunal's power in the adjudication proceeding relating to the discharge or dismissal of a workman should not be limited to that of the tribunal, should have the power, in case wherever necessary, to set aside the order of discharge or dismissal or direct reinstatement of the workman on such terms and conditions, and if any, is seen fit to or give such other reliefs to the workmen, including the award of any lesser punishment in lieu of the discharge dismissal, as the circumstances of the case may be required. For this purpose, the new section 11A proceeded to be proposed to be inserted in the legislation. Now, this is the case. After this case, this section 11A was inserted.
Correct.
Now, probably my learned presiding officer committed an error apparent on the face of the record by not considering this aspect. Now, in order to fortify my contention further, Miller, I would like to refer another judgment. That is probably 2014-10 SSC page 301.
Raghubir.
Huh?
Raghubir.
Yes, Raghubishi.
301.
Yes.
Mr. Ekman.
Okay.
We'll just come back, Mr. Raghubir, 5 minutes.
ওকে দিয়ে দাও না ওটা। Raghuveer Singh's case, para 36 and 37. that on reliance of Firestone.
36, 37.
37.
Please read.
I mean, once the reference is made by the state government in exercise of its territory power to the labor code for adjudication of the existing industrial disputes on the points of the dispute, it is mandatory statutory duty of the labor code under section 11A of the Act to adjudicate the dispute on merit on the basis of evidence produced on record. Section 11A was inserted in the Act by Parliament by Amendment Act of 45 of 1971 with effect from 15 December 1972. With the avoid object to examine the important aspect of the proportionality of punishment imposed upon the important aspect of the proportionality of punishment imposed upon a workman if the acts of the misconduct alleged against the workman are proved. The doctrine of proportionality has been elaborately discussed in this case by interpreting the above provision in the Workmen versus Firestone Tire and Rubber Company, the Firestone case. Now, paragraph 33 they have quoted.
Yes.
The question whether section 11A has made a change in the legal position mentioned above, and if so, to what extent? The statement of object and reason cannot be taken into account. Just now I have read the statement
Yes,
and
yes,
object
yes.
cannot be taken into account. In that judgment itself it is stated.
Yes, yes.
Taken account for the purpose of interpreting the plain words of the section. But it gives an indication as to what the legislature wanted to achieve. At the time of introducing section 11A in the Act, the legislature must have aware of the several principles laid down in various decisions of this code referred to above. One of these cases that referred to above. The object stated to be that the tribunal should have proceeded in cases
Should
where,
have power.
sorry.
Should have power.
Oh, yes, sorry. So the tribunal should have power in cases where necessary to set aside the order of discharge or dismissal and direct reinstatement or award any lesser punishment. The statement of object and reason has specifically referred to the limitation on the power of an industrial tribunal as laid down in the code in Indian Iron and Steel Company Limited, the case that has been referred by the presiding officer.
Okay.
This will be convenient take to consider the contents of section 11A. To invoke section 11A, it is necessary that the industrial dispute of the type mentioned therein should have been referred to an industrial tribunal for adjudication. In course of such adjudication, the tribunal has to be satisfied that the order of discharge or dismissal was not justified. If it comes to such conclusion, the tribunal has to set aside the order and direct the reinstatement of the workman on such terms as it thinks fit. The tribunal has also power to give any other relief to the workman, including imposing the lesser punishment, having due regard to the circumstances. The proviso casts a duty on the tribunal to rely only on the materials on record and prohibits it from taking any fresh evidence. Thus, we believe that the Labor Court and the High Court have failed in not adjudicating the dispute on merits and also not discharging their statutory duty in exercise of their power vested under Section 11A of the Act, and therefore the impugned judgment, order, and award are contrary to the provisions of the Act and law laid down by this court in the above cases. Paragraph 37. Further, the object of insertions of Section 11A of the Act is traceable to the International Labour Organization resolution. It is stated in Firestone and Rubber Company Limited, SC paragraph 3. Just now I have read it.
You have already read.
So let me speak it up.
Okay.
Now, Miller, again, Your Lordship comes to another judgment. That is 2018 1 STC, page 285. Management of Bharat Heavy Electricals Limited. They have developed this idea. Paragraph 18 and 19.
Which one is
Huh?
Management of Bharat Heavy,
Management of Bharat Heavy Electricals Limited.
paragraph?
Paragraph 18 and 19.
Yes.
In our opinion, once the Labor Court upheld the departmental inquiry as being legal and proper, then the only question that survived for consideration before the Labor Court was whether the punishment of dismissal imposed by the appellant to the respondent was legal and proper, or it requires any interference in the question, in the funds. In other words, the Labor Court would have confined the inquiry to examine only one limited question as to whether the punishment given to the respondent was in any way disproportionate to the gravity of the charge linking
Leveled.
Charges.
Leveled.
I have to keep this one. Leveled against them, and this the Labor Court should have examined by taking necessary provision of Section 11A of the Industrial Dispute Act 1947, in short DITRAC, and the law laid down by this court in Workmen versus the Firestone Tire Limited Company.
Yes.
It was, however, not done thereby rendering the order of the Labor Court legally unsustainable. Now, Lord, whether to what extent High Court can examine? It is the duty of the Labor Court to examine. To what extent the High Court can examine this aspect of this case? There are some judgments, but yesterday I could not trace out all those judgments, but I got one judgment. That is 1999 9 SCC, page 259. But
Senapati.
yes, there are 9.
9.
It is well stated that the powers of the Labor Code under Section 11A are wide, and that if it would be open to the High Court in justifiable cases to modify the order of the Labor Code. it will be open to the High Court justifiable cases to modify the order of the labor code. It is also permissible for this court under Article 136 of the Constitution in appropriate cases to alter the punishment imposed on the workmen for doing justice between the parties. In view of the facts stated above and the subsequent development when have taken place after the order of the dismissal, we are inclined to modify the order passed by the labor court. At the same time, we would safeguard the interest of the workman by treating him as a probationer, etc. Now, my lord, this aspect of this case was totally ignored by the presiding officer. He was of the view that yes, labor court inquiry conducted by them is fair. And in view of the Indian Iron case, my power is very much limited to that effect, that your lordship will find at page 23. Let us start it from,
Yeah, just a minute, just a minute.
let us start it from page 22 at the bottom, last but 2 lines.
Just give me 2 minutes. Two minutes.
No problem.
Read paragraph 25 on the earlier case regarding the High Court's power.
Paragraph 25.
25 of this judgment, which I am trying to.
1999, 9 is
No, no,
259.
have a look at this. Because 11A has been taken into consideration, then 226. It's a concurring judgment.
Okay.
Please read.
No doubt, while exercising power under Article 226 of the Constitution, the High Court have to bear in mind the restraint inherent exercising of power judicial review. It is because of this that substitution of the High Court view regarding the appropriate punishment not permissible. But for this constant, I would have thought that the lawmakers do desire application of judicial mind of the question of even proportionality of the punishment penalty. I have said so because the Industrial Dispute Act 1947 was amended to insert 11A in it to confer this power even on a labor court public industrial tribunal. It may be that this power was conferred to the adjudicating authorities because of prevalence of unfair labor practice or victimization by the management. Even so, the power under section 11A is available to be exercised, even if there be no victimization or taking recourse of unfair labor practice. In this background, I do not think if we would be justified in giving much weight to the decision of the employer on the question of appropriate punishment in service matters relating to the government employee. This is the government employees case, not the industrial.
No, on the powers of 226. The concurring part says that when 11A has been inserted, giving powers to a labor court or a tribunal to alter a decision, alter a penalty, depending on the gravity of the penalty. Well, why not 226? 226 certainly will have the powers.
Yes.
Though it's a self-contained restriction is there. That is what
Yes, that is the proportionality.
Yes. Because you had referred to the earlier judgment just now,
Mm.
the judgment of Senapati, paragraph 9.
Yes.
Wherein the powers of 136 Supreme Court as well as High Court has just been referred, but this has beautifully explained this part, this concurring judgment. Then when 11A can be can be introduced, giving powers to the labor code. 226 powers cannot be held to be so restricted so as to not to
Exercise that.
exercise the powers of going into the proportionality of penalty.
I will take it up. It is reported in,
This is BC Chaturvedi.
oh, BC Chaturvedi. So,
Justice Ansari has
Oh,
raised
yes,
concurring judgment.
Chaturvedi. There are a number of cases, number of judgments have been delivered. It is the first case,
First.
Chaturvedi. There are some other case. That is, after this is 1995
95.
and this is 1999.
Yes.
There are other judgments have been come up with it. Probably to some extent it has been diluted to some extent. So far the proportionality is concerned nowadays.
No,
Proportionality,
the subsequent cases have said that High Court should not take the role of a primary authority. It is always the primary authority which decides on the proportionality. But in a given case, to shorten litigation, when the charge and the punishment imposed appears to be shockingly disproportionate, then instead of remanding back, punishment which is commensurate to the gravity of the offense can be imposed.
shockingly disturbed. That Wednesbury principles have been employed.
Yes.
Now, look. Now you are come.
Now, what is the issue here now?
The
The
issue
dismissal has been held to be, has been upheld.
up.
And you say that there was no exercise of mind
That is
in-
one of
in-
the aspects.
in not applying 11A, the powers conferred to the Tribunal of Labor Court 11A to inquire as to whether any other penalty less than dismissal is also, maybe also be permissible.
Okay.
On that aspect you are arguing.
That's right. That is one of the limb of my argument.
Okay.
One of the, So in order to fortify these things, just I will take 1 minute time. Right? Bottom portion of page 22
Of the writ petition.
about the writ.
Yes, yes.
It is found in this regard that the decision of Indian Iron Steel Company Limited, 1951 such and such, DIR 1950 such and such, on the following ground, court cannot interfere with the case as follows. Now, this case has been discussed in the Firestone case. And specifically in the statement and object of the section 11A, this was referred to. And in order to dilute the rigor of this case, Lord, this 11A, this case along with the other cases, the 11A was inserted. That aspect of this case was not considered probably. The following ground.
That's what that we have said. Can be held to be par incurium because 11A has not been taken into consideration, number one. And after iron, Indian iron, 11A has been introduced in the statute book and has been explained in Firestone. But this tribunal has only taken into consideration the observation in Indian Ore that tribunal or labor code is not an appellate authority, that it can substitute. But that power has been specifically granted or conferred by 11A. That power, that is okay. That is okay.
Then let us come to the merit of the case.
Yes, then the burden will again come to you that, okay, the 11A powers have not been exercised. Now, if the tribunal exercises 11A, what are the materials to come to a conclusion that anything else than dismissal is also possible?
Yes, yes.
On that,
Yes. That is, yeah. So for that reason, we have to read the judgment award. Now, before going to the entire award, let me give me some factual perspective. Only what happened on 31/3/2004, probably. 31/3/2004.
31/3.
31/3/2004. Well, I will read the judgment, but
yes,
before
yes, yes.
2 boys of garden was called upon to by the office manager, assistant manager, and according to the workman, these two boys was assaulted for doing something.
Who are these two boys, workmen?
No, they are not working.
Who?
They are not working. Then Miller, the tea garden laborer, came and into the office and asked that why you have taken this step. Then according to the workman, that they were again misbehaved and some of them were threatened. Then Miller, one of the workmen, went to the garden and called their co-workers. Thereby, Miller, an assembly took place. And something had happened. There about, according to the management, around 300 to 400 workers came and they have carried out some personals of the management. And when the management, Mr. Saikia probably, Mr. Gogoi, they attacked Mr. Gogoi and Gogoi was assaulted and he sustained some certain injury. That is their case, Milord. And thereafter, Milord, management had no other alternative but to resort lockout. And after resorting lockout, Milord, they initiated a disciplinary proceeding by being charged, etc. And this dismissal was inflicted. That is their case. But in this case, it is very much clear that whether this concerned workman was inflicted with the punishment of dismissal had committed any misconduct or not. That I have, sorry, Milord, I could not take up the record detail, Milord. I shall take your lordship leave to take it up again if your lordship permit me to. At the lunch period, I can take it up. That is one of the one aspect of this case. Secondly, Milord, what I would like to say, the management, while relying upon their inquiry, domestic inquiry, has not examined the inquiry officer. Inquiry officer was not examined. Only the general manager of the garden was examined and he produced the inquiry proceeding.
No, inquiry officer would be examined at what stage? By whom?
By the management.
Where?
For in order to rely upon
In the tribunal.
the tribunal.
In the tribunal.
When they would.
Okay, on the aspect of the fairness of the inquiry. Okay.
Because he is the best person to answer all these questions, and that he was not examined, Milord.
Okay.
And two other points, Milord, that I should not submit right now, Milord, after going through the record, Milord, I will submit two other points. That is, whether the workmen were afforded to submit their representation against the inquiry report. That is subject to. Then my friend told me that was given to. No, you are also not taking note of it because according to him it was given. I shall check it up. Now, let me go through the award. Page 10.
Yes.
That is the terms of reference. Let us keep it up. Whether as usual, whether the management is justified in management or on the tea state in justified in dismissing such and such and such. If not, are they entitled to a reinstatement with full back wages and benefits or other relief? Or in this case, there are 12 workmen are involved, and by this time, 5 expired. In the last occasion, I filed an application for recording the legal years. then my friend raised an objection that will be heard. And that your lordship have dealt this matter, or this order. On the basis of the reference referred by the government of Assam, a case was registered by case number such and notices were issued to the parties to appear. And file their WS. At the same time, both sides also filed their WS to contest the case. The management, it pleaded that the workmen created unruly situation at their tea garden on 31/3/2004 at about 8:30 a.m. without any reason. The workmen, Baneshwar wearing such and such, such and such, such and such, they came to the management office and they demanded Mr. K.K. Gogoi, senior assistant manager, to give justice on assaulting two boys. two boys workmen for their assaulting by assistant manager of their garden. However, the assistant manager, Mr. J.K. Gogoi, tried to pacify them. However, the workmen started to torture him, and the assistant manager, J.K. Gogoi, got injury at his jaw and other parts of the body, and he ran away from the jaw of death. However, the workmen assaulted him at outside also after chasing him, and they put him into the ambassador car and tried to kill him, setting fire on him. Other manager of O.P. Kawal and Mr. R. Bordoloi tried to pacify them. However, the workmen, they showed amenable attitude towards the management. The assistant manager, J.K. Gogoi, got injured seriously and he took treatment different places at different hospitals. The management declared lockout of the garden for volatile situation to prevent the further damage of the garden and also of the management. Thereafter, the management suspended the workmen in question and they are suspended before filing the charge sheet. The management notified the workmen to justify their injury, unruly action. The management failed to get proper explanation from the workmen on their involvement with the situation. As a result of that, the management decided to file charge sheet and to hold the inquiry against the unruly workmen in order to maintain discipline in the garden. Afterward, the management appointed the inquiry officer and the inquiry proceeding was going on fully in presence of the workmen and also the management witnesses. The inquiry officer submitted the report against the workmen and the management accepted the state report. Thereafter, the 12 workmen, they are dismissed from their services. It is also pleaded that all the procedure of hearing are adopted at the time of domestic inquiry. Therefore, there was no reason to think that unauthorized way the management adopted the report of the inquiry of the inquiry officer illegally, and there is an illegality in dismissing the workmen. So it is prayed to dismiss the case. The workmen side, represented by ABCMS, Assam, filed in its WS, it is pleaded that it is fact that the such and such Baneshwar Orang and 11 other workmen have been dismissed by the management on the basis of unfounded allegation and also by holding partial inquiry. The 12 workmen, they are permanent workers of Ananda Tea Estate. As a result of that, ABCMS and CI2, they came forward to defend their case and they raised voice against the alleged illegality. Charge sheets are also filed alleging that all the workmen in question for creating unruly situation on 31/3/2004 at 8:30 a.m. And they assaulted assistant manager, senior assistant manager J.K. Gogoi, and also other managers, O.P. Kual and P. Bordaloi. They also defied the order of other two managers when they advised them to maintain peace and tranquility in the garden, in the interest of the garden. The workmen assaulted manager J.K. Gogoi. Even they pushed him inside the ambassador car for the purpose of killing him by setting fire. It is pleaded that the above charges are framed in the departmental inquiry against them. It is pleaded that the principles of natural justice have not been followed fully. The workmen are dismissed on illegal departmental inquiry, and it was done with a pre-motivation. As a result of that, for not fulfilling the requirement of principles of natural justice, the inquiry against the workmen as conducted by the department is vitiated, and the management cannot act on the basis of the report of such proceeding. It is also pleaded that the criminal case was given against them by case number such and such in between the state of versus such and others, and they are acquitted by the additional session judge Lakhimpur by the order dated 29/5/2006. It is pleaded that therefore the domestic inquiry report may be quashed or set aside, and is also prayed to pass order for their reinstatement as well as the back wages. For that, an order may be passed. It is also found in additional written statement that that as they had got acquittal in the charge level against them in the criminal cases. For that, there is no reason to accept the domestic inquiry, the report thereof. Therefore, it is prayed to set aside the order of the inquiry officer forthwith. The learned, the advocate, and the representative of these parties are present. I have heard both and both sides. Accordingly to decide the matter, I have framed. That is the preliminary to that was framed. One preliminary issue on the point whether the principles of natural justice have been followed at the time of domestic inquiry. In this regard, I have found, that is real issue. In this regard, I have found that the inquiry officer, A.K. Goswami, who was appointed by the management for holding inquiry. The inquiry was held at the office of the general manager, and it was held in proper time around 9 a.m. to 10 p.m. Yeah, 9 a.m. to 1 p.m., sorry. And again from 2 p.m. to 6:30 p.m. And on 6/26/2004 and 27/6/2004, respectively. At the time of holding inquiry, there are two independent observers. They are such and such, employees of the Alanti state. And the management submitted all papers for intimations of the proceeding.
Initiation.
Initiations of proceeding. The management charge sheeted against the 15 workers. They are such and such.
Okay.
Out of 15 workers, 10 workers were male and 5 workmen were female. The inquiry officer on 26/3/2004. Okay. All right. The inquiry officer on 26/3/2004 explained the purpose of inquiry. Yes, it will be 26/6 or something because offense took place on 31/3/2004. it will be some other date. Then, and also.
It is 26/6 actually, because if you
Ah.
come to 6 lines above, there are two dates, 26/6 and 27/6.
Yes, yes, yes. Yes, yes, it will be 26. Explain the purpose of inquiry and also procedure thereof, how to be followed there. It is also explained the contents of the charge sheet dated 6/3/2004 and also contents of the reply dated 9/6/2004. Accordingly, the inquiry officer, Mr. A.K. Goswami, started recording evidence of the management witnesses, and also the reply of the workmen was that they have no involvement, of the alleged incident. The management side examined Mr. R.K. Parekh, General Manager of Anand Tea Estate as MW1. MW2 is J.K. Gogoi, who has been examined, and MW3, Mr. R. Bardoli, MW4, Mr. O.P. Koal, and Assistant Manager, MW5, Mr. R.K. Das, MW6, Mr. D.K. Bora, MW7, Mr. Sachin Bhuya. They are also examined as MW8, MW9, MW10, etc., to examine them properly. The workman side also examined workman witness such and such, such and such, such and such. From the evidence,
Yes.
from the evidence of R.K. Parekh, MW1, found that at the time of incident he was at Shillong. And he came to know of incident occurred on 31/3/2004. That workman assaulted and tried to kill the assistant manager, J.K. Gogoi, MW2, by putting him into the ambassador car by fire, the same to kill Mr. Gogoi. And the workman assaulted him for reason, and he tried to escape from the hands of the workman. He ran away and jumping over the wall. It is also found from his evidence that outside of the workman, workman also assaulted him. As a result of that, they become bound
to
to
declare lockout.
lockout of the factory on 1/4/2004. Well, this MW1 was not present.
Okay,
He was
let
at
us,
Shillong.
let us ignore MW1, come to MW2,
Uh,
Gogoi.
yes, yes. No, he also
MW1, we can say he's a hearsay, so may not give much of a
much
credence.
credence. He also proved Exhibit 1 FIR
Mm.
filed by J.K. Gogoi, Exhibit 2 of the lockout notice, Exhibit 21, 22 signature of witnesses, Exhibit 3 letter dated 2/4/2004, addressed to SP, prevent their life. Exhibit 31 is signature. Exhibit 4 is a written to OC, 3/4/2004, and Exhibit 41 the signature of MW1, R.K. Parekh.
Hmm.
He also proved Exhibit 10 notices as withdrawal of lockout. Exhibit 10,
This you can skip,
let us keep it, no?
according his, some,
Accordingly, he issued suspension order.
this also you can skip.
Let us keep. Then Miller, J.K. Gogoi. It is also pleaded that MW2 workmen should compensate the company. That is the MW1 statement. You should skip it off, Lord. It is also pleaded that MW pleaded as per MW2, the workmen should compensate the company for damaging the company's property. MW1 proved Exhibit 31 to 53. These are the documentary evidences that was exhibited by MW1. Lord. Now, Now let us come to MW2.
Yes.
That is page 15. After 1, 2, 3, 4, 5, 6, 7th line.
Yes. In this regard.
In this regard,
Yes.
MW2, J.K. Gogoi, he also say that who is injured. He also say that who is injured, probably
He was injured.
he was injured that the time of incident occurred on 31/3/2004. He was at his office. Now, only the Gayatri Biru, he named 3 persons. Gayatri, Biru, Banesar, Pradip came to his office.
Four persons.
Huh?
4 persons.
Gayatri, Biru, Banesar, Pradip.
4 persons. 4 persons.
Oh, yes, yes,
Not 3,
yes,
4
yes.
persons.
Sorry. Came to his office to misbehave him. They demanded Bichar on assaulting 2 boys of the garden. However, workman Pradip went outside and thereafter he called all to come to the garden office. And on his calling, the workmen of the workers started to come to the garden of the garden office. And Banasteri again went to the garden and brought their workmen, Budni, such and such, Gayatri, Pradip, 4 persons, Budni, Gayatri, Pradip, and they also charge sheeted against him. Same from the J.K. Gogoi also confined by the workers and assaulted him, created hue and cry, and they declared that they will kill J.K. Gogoi. Then the workmen Istar pushed him inside the office and car, and Fanidhar, Biru, Banester, Ajoy
Instructed.
others to assault him. MW2 further said the assistant manager O.P. Koel and R.K. Bordoli tried to save him, but the workmen attacked them. The workmen damaged the gate of the tea garden. The workman Langu Fanidhar Istar caught him at his neck and dragged him on the garden road. MW2 tried to get rid of the workman. However, the workman chased him and the workman used knife, rod, stone, etc. And he was under the lock into the room, and they had intention to kill him even. Langu, Banester, Ajay, Pradip, Istar, Banester also put him inside the ambassador car to kill him. Ali, by setting fire. The assistant manager got injured, both upper and lower jaw and other parts of the body. Pradip again pushed him, catching him neck, and other workmen attacked him, and blood came from the wound. Therefore, he was rescued by the other MWRK Das. MWRK Das took him in the police station and medical also treatment. One DK Bora went to Chaldoa outpost to inform the matter of the unruly act of the workmen at the garden. MW2 stated that he got grave injury for which he had to take admission in Defiant Hospital. Exhibit 10, 70 to 77 are the certificate of the treatment, and also he had to take bed rest for many a month due to getting injury at the hand of the workman. Yes, reporter. From examination, it is also found that Budni, Banester Orang, Langumrang, Bina, etc., and suggested that they are not present that is Baneskar Orang, Lungi Munda, Bina, Honidar, Iskar, Bharat, Ajay Orang, Ram Prasad Orang, Pradeep Tharia, Timothy Gayatri, Timothy Fully Barak, Timothy Dubai, Judy, Timothy said and suggested they are not present at the time of incident and they have no hand at the incident. R.K. Bordoloi, MW3, said that the workmen Gayatri, Veena, Banasari, Pradeep, initially they came to meet MW2. However, thereafter, all the workmen came there. Budni confined him and Gayatri, Langu, Ramprasad raised Allah and calling the workmen incited them to create disturbance at the garden. It is said in the cross-examination of MW3 and MW2 the same way also without variation. MW4 OP Kual said that he saw 300 to 400 workers were outside the office to create nuisance and he tried to pacify the workmen. However, the workmen tried to kill MW2 and also started to assault him by the workmen and they created unlawful assembly to commit the offense of rioting all at the garden office. MW4 Om Prakash Goel expressed that the workmen named thereof have already cited are involved in the incident. J.K. Gogoi got grievous injury and blood came out from the wound. In his cross-examination, he said that Budni suggested that she did not assault Mr. MW2. However, she said that by suggestion that the other workmen and women, they are present there at the time of the incident. MW5 Rajanikanto Das and MW6 D.K. Bora also say that the relevant day, 300 to 400 workmen gathered around the garden office and attacked MW2 J.K. Gogoi. The workmen Chuck Langu, they are also involved with the other workmen and women. However, the other workmen, women denied their involvement.
Okay, we'll resume at 2 o'clock. But MW2's version is very direct.
Supported by 4 and
Even if we ignore one, we have not read the version of the other management witness, but 2 who was the injured witness. And his testimony has to be given more weightage because he is the injured himself.
Yes, you got it.
But they got acquittal in the criminal case.
Yes. Acquittal.
So we need to also address on the issue of standard of proof in a criminal proceeding as well as in a domestic inquiry.
acquittal on benefit of doubt. The acquittal in the criminal case was on benefit of
No, even the standard of proof, that's
different.
that is,
Defined preponderance of evidence
here,
and beyond reasonable doubt.
Preponderance
Okay,
of
we'll come back.
probability.
Milord, this is a very unfortunate case. I have gone through the ATR record. It appears to me that no evidence was taken.
No, or what about these evidence?
These are the domestic inquiries.
Understood. Now, if the
But
fact,
this evidence was not proved. Simply placed before them. And even what is interesting thing is that the management himself filed an application. And they wanted to examine the inquiry officer to prove the evidence of domestic inquiry. And that was not even allowed. If your lordship goes,
There was not even, it was objected to by the advocate of the workman saying that the inquiry officer cannot be examined.
anyway, let me please.
Lordship will have a look at the order of 9-8.
All right, you will take your chance.
okay. Yes. We are at page 15.
Hmm?
MW2 JK Gogoi.
Should we go through the order sheet? I think, Lord, it can be finished in that way.
Okay.
For the timing,
Okay.
we
Okay.
keep it up, Lord.
Okay.
Now,
Okay.
your Lordship may please go through the order sheet.
In the records.
Record.
Yes, please.
Date start from
24/7.
no 17/7/2009. 17/9.
Yes. No, it starts at 24/7 actually.
Anyway, 24/7 when the notification.
Yes, it was received by the court.
Now, my lord, thereafter several dates. In all those dates, my lord,
Yes.
there's filing of Hajira, etc., the filing of WS, etc., etc., etc. Now, my lord, your lordship straightway come to 3/1/2011.
Three?
3/1 to 3rd January 2011.
Yes.
On that day, date of evidence was fixed.
3/1/11. Okay. Management side. Okay. Absent without steps. Workman has filed a petition stating that due to mistake of the date, it has not appeared in the last date and prayed for acceptance of additional WS and copies of the documents. Yes, what is this? What is in 3/1/2011?
On that day, 14/11/2000 was fixed for evidence. 24/11/2000,
Yes.
24/1. On 3/1/2011, date of evidence was fixed on 24/1/2011.
Yes.
Okay.
Yes.
And the union was called upon to adduce evidence. All right. On 24/11, union filed an application praying that the management should lead the evidence. Got it?
Yes, management side is absent. Petition. Yes.
Now, my lord, here, objection hearing took place. Who will lead evidence? Hearing took place.
Yes.
On different dates were fixed.
Yes.
So say about 20 or 25 days went on. All dates. Then your lordship, come to 19/11/2011.
Yes.
Now, my lord, at one point of time, our High Court passed an order
Yes.
to the effect that it should be transmitted to the district court because of paucity of the judges, presiding officer. It should be tried by the district court at one point of time. Because of that, this matter went to the district court.
Yes.
That is in 19/1/2011.
Yes.
District court. Achha. Then your lordship come to 17/4/2012 order.
Yes.
Fixed for hearing. 17/5/2012.
Yes.
Normally several days went on. No hearing took place. Then your lordship come 9/8/2012.
Nine,
8/2012. Here, your lordship, I could not write entire order, but some substance I have wrote here. 9/10/2012, learned advocate for the management filed a petition number 15/2012. Got it? Dated 16/7/2012, praying to allow the inquiry officer of the domestic inquiry. क्या लिखा है इसमें?
Dismissal of court.
So for dismissal of the workmen, petition is found that they would rely on the inquiry fully for the adjudication of the case. So they wanted to examine the inquiry officer. For
Yes.
that purpose, now they volunteered, yes, all that we shall adduce evidence part.
Mm.
And for that purpose, they filed an application
Mm.
whereby they prayed that they should be allowed to examine their inquiry officer. Okay. And have the allow to provide evidence to the, just a minute. To prayer allowed to give evidence by the domestic inquiry officer rejected. That prayer was rejected. So ultimately, even the management's prayer was also rejected. By rejecting that prayer,
yes,
the learned presiding officer framed a preliminary issue.
yes,
That preliminary issue is whether the domestic inquiry conducted by following the inquiry क्या लिखा है इसमें?
Inquiry principles
Of natural justice.
So the next date is 30.
So the next date is fixed on 30/8/2012. So sum and substance of this case is that both the parties filed their written statement, additional written statement, they filed their documents with regard to the inquiry, and at one point of time, the court asked the workman to adduce evidence. Workman filed an application, no, management shall adduce evidence. For a number of days went away. Thereafter, the management volunteered to adduce evidence by examining their inquiry officer, but that application was rejected, and the presiding officer was under the impression that without examining any evidence, he can examine the fairness of the inquiry. And then he, on perusal of the material and document, he gave this time. So no evidence was taken. Now, my lord, your lordship file. Then, my lord, on 39/2012, management side filed a petition praying a written argument.
yes,
But it on 27/9/2012, fixed for written argument. क्या लिखा है? Written argument. Anyway, management shall fix, management side shall file written argument on 1/12/2012. Workman shall file written argument, award reserved.
the earlier date is not 39, it should be 38.
38, yes. 38.
Because the earlier date
Yes,
was
yes.
fixed on 38.
38.
So
That is,
because 39 will not fix 27/9.
yes, that we have noticed. Then award pass.
Hmm.
Now, Millard, right now, probably I will not be able to bring it out, but I brought this judgment. What is the material on record in a case? That has been stated in section 11A. And this is so long because I was not prepared for this situation. And in this judgment, Millard, there is one paragraph that material on record means written statement, additional written statement, and the evidence.
Citation,
Um,
citation.
citation blood, I'm not subject to rectification. It is probably in the Firestone's case. That is your, before your lordship will find somewhere. Or your lordship will kindly hear tomorrow, if possible.
No, we'll complete this.
Yeah, I think it can be,
We can complete this.
it can be completed. Material on record. I vividly remember in,
It is there in Firestone only.
huh?
It is there in Firestone.
No, it is there in
We
Firestone,
remember.
because where it is, I cannot.
No, I'll give you the.
Material, what is material on record?
Come to page paragraph 47.
Paragraph 47. I read it, but now I cannot locate it. We will now pass on to consider the proviso to section 11A. Mr. Deshmukh relied on the terms of proviso in support of his contention that it is now obligatory to hold the proper domestic entry, and the tribunal can only take into account of the materials placed.
Come to 48, 49. Yes, this is very
48,
specific.
49.
We are not inclined.
We are not inclined to accept the above contention of Mr. Deshmukh. The proviso specified the matters which the tribunal shall take into account, as also the matters which shall not. The expression yes, that is, I could not locate it out. The expression material on record occurring in the proviso, in our opinion, cannot be confined only to the materials which are available at the domestic inquiry. That is hard. On the other hand, the materials on record in the proviso must be held to refer to materials on record before the tribunal. They take in the evidence taken by the management at the inquiry and the proceeding of the inquiry, or the above evidence in addition and further evidence laid before the tribunal. Evidence placed before the tribunal for the first time in support of the action taken by the employer, as well as the evidence adduced by the workman contract. The above term by and large, should be considered to be the material on record as specified in the proviso. We are not inclined to limit that the expression meaning only that the material that has been placed in a domestic inquiry. The proviso only confines the tribunal to materials on record before it, as specified above. When considering the justification or otherwise of the order of discharge or dismissal, it is only on the basis of the materials that the tribunal is obliged to consider whether the misconduct is proved, and further question whether the proved misconduct justifies the punishment of dismissal or discharge. It also provided the tribunal from taking any fresh evidence, either for satisfying itself regarding the misconduct or for altering punishment. From the proviso, it is not certainly possible to come to the conclusion that when once it is held that the inquiry has not been held or found to be defective, an order of reinstating the workman will have to be made by the tribunal. Nor does it follow that the proviso deprives the employer or his right to adduce evidence for the first time before the tribunal. The expression fresh evidence has to be read in the context in which it appears, namely, the distinguished from the expression materials and record. If so read, the proviso does not present difficulty as at all.
How do you reconcile? How do you reconcile the proviso of 11A with these observations? Can you read the proviso to 11A?
No, industrial dispute rules is also applicable here.
No, no, but can you read the proviso to 11A?
11A,
Proviso,
yes, definitely.
provided.
Provided that in any proceeding under this section, the Labor Court Tribunal or National Tribunal, as the case may be, shall rely only on the materials on record and shall not take any fresh evidence in relation to the matter. Materials on record means the
And shall not take any fresh evidence.
fresh evidence.
And this is exactly what the Learned Labour Court has taken into consideration while passing the order of 9/8/2012.
Hmm.
In the order of 9/8/2012, which you had referred of the order sheet
Hmm.
before the Learned Labour
No,
Court.
no, Miller, one
The-
thing.
No, just a minute.
Just a minute. All
The
right.
petition was filed by the management to adduce evidence of the inquiry officer.
Ah.
Okay. There was objection by the workmen,
Hmm.
taking into account proviso to 11A.
Hmm.
That under proviso to 11A, a labor court is not entitled to take fresh evidence.
Hmm.
It has to decide on the basis of the materials already on record.
Hmm.
And taking that into consideration, the prayer was rejected. And while rejecting, the Learned Labour Court had framed a preliminary issue.
All right.
But generally what
One
we
thing, I just,
generally what we understand is if in a given case the fairness of the domestic inquiry, the tribunal is not satisfied. In a given case, the management says that this is the domestic inquiry, we had followed this. Tribunal comes to a finding, no, there is a violation of principles of natural justice. So, on the basis of the domestic inquiry, we cannot uphold your action. So, you are given a fresh opportunity to prove the case in the tribunal. So, how is that situation commensurate or rather
no,
in sync with the proviso to 11A?
one should introduce the document through an evidence. That is the rule under Industrial Dispute Act. Industrial Dispute Rules.
No, but
But here,
proviso. What is the proviso?
no,
Sir, last part.
one should introduce the how the document is to be introduced. That is the rule. But through the evidence.
Yes.
But here no evidence was. Otherwise, Millard, simply because by producing certain documents, one cannot examine, cannot come to a conclusion that the inquiry was.
No, you are
Some-
you're absolutely correct. Only because by producing certain documents, it does not become a proof. You have to prove it by an evidence, by a witness.
By an witness.
But what about the proviso? What proviso says
No,
that you
proviso,
cannot take fresh
that
evidence.
is my understanding is that when the inquiry proceeding has been duly proved, inquiry proceeding has been duly proved, after proving of the inquiry proceeding, you cannot introduce a fresh evidence.
Now, please read again.
Yes,
Pro-
sir, I have,
Provided.
I have not brought that judgment.
No, again read the proviso. Provide.
Let us read the entire section.
No, entire section may not be necessary.
Okay. Provided that in any proceeding under this section. Prior to that, what happened? If you have proved inquiry proceeding and the court is of the view that the inquiry is fair, then court shall not interfere with the punishment inflicted on the delinquent, punishment of inflicted on the delinquent. That has been diluted by insertion of section 11. It is stated just so far the punishment of dismissal or the discharge is concerned, it can be interfered. But while interfering these things, no fresh evidence is to be required to be based. If we read that, provided that if we read the statement and object of the Firestone, let us read it again.
No, we have read it, we have read it.
In the Firestone statement of reading, they have referred this that 1958 SC page 130.
I don't know.
I don't know. And it is stated that in that judgment, when the inquiry is established to be fair, then this court has a very, very limited scope to interfere. Only in certain cases, the court can interfere. Court can interfere. So those cases are the victimization, unfair labor practice, etc. and etc. Now, in order to dilute this judgment or the earlier judgment, this section 11A was inserted in consonance with the International Labour Organization's regulation number 119, which was adopted in the year 1963. Now, here it is stated that after conclusion on the subject matter of the fairness of the inquiry,
Yes.
if the punishment has to be interfered, no fresh evidence is required. This does not mean that only the inquiry. You have adduced your evidence by placing all the materials on record. If your lordship goes to the Ludbur Singh's case, I have brought this judgment, then it will be clear. If you have adduced your evidence through an evidence, through a witness, and court was of the view, yes, what the inquiry you have conducted, that is just fair. If that conclusion comes, then court shall not interfere with the punishment inflicted on.
What does Ludbur say? What does Ludbur Singh say?
Ludbur Singh judgment, I have not brought, but the relevant paragraphs have been cited in the Ludbur Singh. Just a minute. In one of these judgments is Ludbur Singh. Ludbur Singh Delhi Cloth Mill is 1972, but I have not brought it, but the relevant paragraphs have been put at here.
Perhaps, my lord, Ludbur Singh's citation is referred in the 9/8/2012 order.
No, we can have Ludbur Singh,
No.
no problem. Okay.
Yeah, 72.
Delhi Cloth Mill, Walter Ludbur Singh. Yes, I am giving it.
Ludbur is GCM, isn't it?
Delhi Cloth.
Delhi Cloth Mills versus Ludbur Singh. Yeah, 1972.
72, yes.
The page number is not this. My Pankaj Chakraborty, all these cases were placed. One judgment, 1984 AIRST 289.
84, what is the name?
Forget the name. Page is 289, page number I can remember. Shankar Chakraborty subsequent to Shankar Chakraborty's case. KIR 1984 SC 289. Ludbur Singh's case here discussed. Okay. Shankar Chakraborty versus Britannia Company. Then first Ludbur Singh, then Shankar Chakraborty Britannia Company. Then AIR 84, page 289. Forgotten, Justice Desai judgment. Just a minute, 1 minute, I'm Ludbur Singh. क्या हुआ है? देखा है कल?
What is the definition of an award?
Yes, award rule section 2.
To be.
To be. Award means an interim or final determination of an industrial dispute or any question relating thereto by any labor court, industrial tribunal or national tribunal, and includes an arbitration award made under section 10A.
Now, before insertion of 11A, were the powers of the tribunal and labor court restricted?
Yes. Before insertion of 11A,
There was no restriction. 11 only says that in two conditions of dismissal or discharge,
yes,
the labor court can
interfere.
substitute the punishment.
Yes.
It
But
is only
what-
for substitution.
What-
Otherwise, interference was already there. Our determination of a reference of a dispute. One cannot say that labor court or tribunal is not having the powers to set aside a dismissal.
Yes,
or-
yes. That can be, but for limited ground. That is the case. There is AIN 19
Indian ore.
Indian law.
Or iron ore.
Iron ore.
Indian iron.
That is the case. And my learned presiding officer has relied upon that judgment. So your lordship goes through that judgment. This at page 23. These are four grounds. क्या When there is want of good faith, when there is victimization or unfair labor practice, when the management has been guilty of basic error or violation of principles of natural justice, when on material finding completely baseless and perverse. What your lordship saying?
That original case.
Our case.
On original that
1958 case.
50, yes. Yeah, 1958 Supreme Court 130. Mhm. Mhm.
और फिर क्या आ जाएगा यही तफावत नहीं है क्या बोल रहा है तीन जजमेंट है आपकी
See, Mr. Dasgupta, you had pointed out that International Labour Organization's recommendation 119,
9
whereafter 11A was incorporated even to overcome the restrictions imposed by in the case of Indian Iron. Now 11A, let us read it very carefully, the main part which you wanted to read. 11A. The substantive provision. Where an industrial tribunal relating to the discharge or dismissal of a workman has been referred to a labor court, tribunal or national tribunal for adjudication, and in the course of adjudication proceedings, the labor court, tribunal or national tribunal, as the case may be, satisfied that the order of discharge or dismissal was not justified, it may, by its award, set aside the order of discharge or dismissal and, this is and, direct reinstatement of the workman on such terms and condition, if any, as it thinks, or, this is or, this is
give
or,
such other order
this is or give such
Other
other
relief.
relief to the workman, including the award of a lesser penalty.
in lieu of discharge dismissal as the circumstances of the case may require.
So the heading probably of 11A
That-
is slightly deceptive because the purpose of 11A is to give the powers to the labor court to interfere even with orders of discharge and dismissal and direct reinstatement. And in an appropriate case, also suggest
some other order.
other penalty.
In the event that even if it is found that the inquiry is fair. Inquiry, prior to that, what happened? If the inquiry is fair, the court's power is very much limited. Only victimization, unfair labor practice.
That was in the Indian ore case.
Indian ore
case. Indian iron.
Now you are lost to find. I will pick this three cases, Shankar Chakraborty, Britannia, and Ludbut Singh. And 2008, Ved Prakash or something like that. Now you are lost to find. Yet, yeah. 73(1) SPC, paragraph 3.
Okay.
Paragraph 3. 76(1) SPC, page 813.
76.
Sorry, 73(1) SPC, page 813.
Have you given copy? No.
Huh?
Have you given a copy? No.
Yes, please, we gave it a copy.
1970?
1 SPC.
81. Oh, that Firestone.
Firestone.
Yes, that we have.
Now, paragraph 3. Regarding section 11A.
That we have just read. That we have read. That we have read. I think 12 and 13, if you read 12 and 13 paragraph, everything will be clear.
Is it?
Yes.
Then also.
12 and 13. That explained everything.
originally, limitation had been placed by the judicial decision in respect of the jurisdiction of the labor court when considering the action of an employer in the matter of discharge or dismissal of a workman. If a domestic inquiry had been held by an employer on the basis of which a workman is dismissed or discharged, the labor court can interfere with the decision of the management only if the domestic inquiry is vitiated by the circumstances mentioned by this court in Indian Iron, yes, Indian Iron and Steel Company Limited versus and another versus their workmen.
It was a very restricted
Yes, that
power.
restricted power. Yeah.
Yes, then
Once the tribunal hold that once the tribunal hold that the domestic inquiry has been conducted properly, and the action of an employer is bona fide and conclusion arrived thereon are plausible. They had no jurisdiction to substitute their own judgment. In cases where the management conduct,
where the misconduct?
where the misconduct is found to be proved by a valid, proper domestic inquiry. Valid, proper domestic inquiry, the tribunal had no power to alter the punishment imposed by an employer. Even in cases where the domestic inquiry is held to be defective, or even if the order of termination or discharge, the employer was given an opportunity to adduce evidence before the tribunal to justify his action. Once the tribunal accepts the evidence and holds that the misconduct is proved, it had no power to interfere with the discretion of the management regarding the quantum of punishment. The above position has been completely changed
By 11A.
by 11A. By section 11A, it is now obligatory on an employer to hold a proper domestic inquiry in which all material evidence will have to be adduced. When a dispute is referred for adjudication and it is found that the domestic inquiry conducted by the management is defective, or if it is found that no domestic inquiry at all had been conducted, the order of discharge or termination passed by the employer, however, without anything more unjustified, and the labor tribunal have no option but to direct the reinstatement of the workman concerned, as his discharge or dismissal is illegal. Even in case where a domestic inquiry has been held and finding misconduct recorded, the labor tribunal have now full power and jurisdiction to reappraise the evidence to satisfy themselves whether the evidence justifies the finding of the misconduct. Even if the inquiry proceedings are held to be proper and the finding of misconduct is also accepted, the tribunal has now power to consider whether the punishment of dismissal or discharge was necessary for the type of misconduct of which the workman is found guilty. In such circumstances, the tribunal can also give any other relief to the workman, including imposing a lesser punishment. In case where an employer had not conducted an inquiry, or when the inquiry conducted by him is held to be defective, the employer will not be given any, that case is Bank of Baroda's case, AIR 1984, page 289. Now I have called. In case whether the employer had not conducted any inquiry, or when the inquiry conducted by him is held to be defective. Somunath 12 versus Bank of Baroda. Yes, you are correct. Have not conducted any inquiry, or when the inquiry conducted by him is held to be defective, the employer will not be given any opportunity to adduce evidence before the labor code for justifying his act. Miller, here it is the proviso. May I read it again? In case when the employer had not conducted any inquiry, or when the inquiry conducted by him is held defective, the employer will not be given any opportunity to adduce evidence before the labor code for justifying action. Various decisions of this court have emphasized that there is an obligation on the part of an employer to hold a proper inquiry before dismissing or discharging a worker. And it has been stated that the inquiry should conform to certain well-defined principles, and it should not be an empty formality. If the management, being fully aware of the position in law, does not conduct an inquiry or conducts the defective inquiry, or the order passed by it is illegal, and it cannot take the advantage of such illegality or wrong committed by it and seek further opportunity before the tribunal to adducing evidence for the first time. Generally, the standing order also, but so far proviso is concerned, subject to rectification by your lordship. Proviso, what is in my mind, that yes, you have conducted an inquiry. Inquiry is held to be justified, fair or proper. Then court is of the view, we shall interfere under section 11A. So while exercising his power 11A, the management should not be allowed to adduce any further evidence, which is beyond the material. I have conducted an inquiry. Inquiry I have established, yes, it is fair and proper. Only thing is that whether the punishment is justified or not. In that case, my lord, I should not be allowed to adduce any further evidence. But on the contrary, Judge Ludbosting's case, that yes, now I can remember. If the inquiry is invalid, but management filed an application, you see, we should like to rely upon the inquiry at a first instance. And if the inquiry is unfair, then we should be allowed to adduce evidence on merit.
Yes.
Then management should be allowed to adduce evidence on merit if the inquiry is found to be invalid. But so far, Shankar Chakraborty, Ludbut Singh is not so very clear. Shankar Chakraborty and Bank of Baroda's case, it is stated that you should make a prayer that you will rely upon the inquiry, and in the event the inquiry is found to be defective, then you should be afforded with an opportunity to adduce evidence. That is the ratio of the.
And that that plea has to be taken in the written statement itself. It is not after the inquiry is held to be bad.
In the Ludbut Singh's case, it was staged at any stage. Thereafter, it was restricted.
Somunath Goel's case says that it has to be taken in at the stage of filing.
No, the management can take a plea before the tribunal or labor court at the first instance that you examine the fairness of the domestic inquiry. If I fail on the domestic inquiry fairness part, then I may be given the opportunity to prove my case.
Yes.
That is what is the law following now.
That was very much cleared by the Ludbut Singh's case.
Yes, Ludbut
But
is
it
very
was
clear.
further developed by subsequent Shankar Chakraborty as well as the Somunath Goel.
There are two, three more cases.
Two or three cases are there.
Oh.
When the inquiry is declared to be unfair, no part of the inquiry proceedings shall be considered as material on record.
I think Firestone has also said something on the fairness part. Firestone has also said something.
That may be. That is, you'll also find that paragraph 20, they have indicated something.
Yes, yes, yes,
Paragraph 20. My God,
yes.
they have discussed all these cases. Then it was further laid down that an employer ought to have a right to decide what the appropriate punishment for the misconduct
Yes,
would be.
no, read 30. 30 will make it clear. 30.
Is it?
30, yes, yes. Ludwood has been taken into consideration. I was looking for this paragraph.
Oh, yes, yes. Yes, yes. This code in recent decision, in Delhi Cloth Mills versus Ludwig Singh, after a review of all the earlier cases, has summarized the principles flowing out of those decisions.
Yes.
It has been emphasized that when no inquiry has been held by an employer, or when the inquiry has been found to be defective, the employer has got a right to adduce the evidence. That is clear. Right to
Before the tribunal justifying its action.
justifies it. The stage at which the employer should invoke the jurisdiction of the tribunal to allow him to adduce evidence before it has also been discussed in the
Yes.
state decision.
Hmm.
We have exhaustively referred the various decisions of this court, and they have clear and they gave a clear picture of the principles governing the jurisdiction of the tribunal when adjudicating the dispute relating the dismissal or discharge. From those decisions, following principles are broadly emerged. Number one, right to take disciplinary action, and two,
You can read 4.
court. Even if no inquiry has been held by an employer, or if even no inquiry has been held by an employer, or if the inquiry held by him is found to be defective,
Yes.
the tribunal, in order to satisfy itself about the legality and validity of the order, had to give an opportunity to the employer and the employee to adduce the evidence before it. It is open to the employer to adduce the evidence for the first time, justifying his action, and it is open to the employee to adduce evidence contrary. So in the event that the inquiry is declared as unfair, even if no inquiry has been held,
6, read 6.
3, the tribunal gets jurisdiction to consider the evidence placed before it
And
for the first time in justification of the action taken only.
and 8.
If no inquiry has, 8, an employer who wants to avail himself the opportunity of adducing evidence for the first time before the tribunal to justify his action should ask for it
Yes.
at the appropriate
Which you have
stage.
just said some time back that you have to make a prayer for it.
A prayer for it. But in the subsequent case, it is made clear that no, at the very first instance, he should pay.
Yes. And, the tribunal has no power to refuse.
If such opportunity is asked for, the tribunal has no power to refuse. The giving of an opportunity to an employer to adduce evidence for the first time before the tribunal is in the interest of both the management and the employer, and to enable him and to enable the tribunal itself to be satisfied about the alleged misconduct. Once the misconduct is proved, either in the inquiry conducted by the employer or by the evidence placed before the tribunal,
Yes.
for the first time, the punishment imposed cannot be interfered with by the tribunal, except in case where the punishment is so harsh and suggests to victimize. In a particular case, after setting aside the order of dismissal, whether a workman should be reinstated or paid compensation is held by this court in the management of such and such within the judicial decisions of the labor court and the tribunal. The above was the law laid down by this court as on 1st December. That is whether it is retrospective or prospective. It has been held that section 11A is have a prospective effect. The question is whether section 11A has made a change in the legal position mentioned above. If so, to what extent? The statement of object and the reason cannot be taken into account for the purpose of interpreting the claim plain words of the section. But it gives an indication as to what the legislature wanted to achieve. At the time of introduction, section 11A, in case of the act, the legislature must have been aware of the several principles laid down in various decisions of this court referred to above. The object is stated to be that the tribunal should have a power in case where necessary to set aside the order of the discharge or dismissal and direct the reinstatement or award any lesser punishment. The statement of object and reason has specifically referred to the limitations of the power as an industrial tribunal as laid down by this court in the Indian Iron Ore Steel and Company Limited, specifically referred. This will be a convenient state. This will be a convenient state to consider the contents of section 11A. To invoke section 11A, it is necessary that the industrial dispute of the type mentioned therein would have been referred to the industrial tribunal for adjudication. In course of such adjudication, the tribunal has to be satisfied that the order of discharge or dismissal was not justified. If it comes to such conclusion, the tribunal has to set aside the order and direct the reinstatement of the workman on such terms as it thinks fit. The tribunal has also power to give any other relief to the workman, including the imposing lesser punishment, having due regard to the circumstances. The proviso cast a duty, the proviso cast a duty on the tribunal to rely only on the materials on record and prohibit it from taking any fresh evidence. Even a mere reading of the section, in our opinion, does not indicate that a change in law as laid down by this court has been effected. According to the workmen, the NTL law has been completely altered, whereas according to the employer, the very minor change has been effected, giving the power to the tribunal only to alter the punishment after having held the misconduct is proved. That is, according to the employer, the tribunal has a mere power to alter the punishment after it holds that the misconduct is proved. The workmen, on the other hand, claim that the law has been rewritten. Just now, your lordship has stated that there was no such major change. Prior to Firestone, the court could have interfered. Even after Firestone, court can interfere. Only difference is that prior to Firestone, the power of the court to interfere with the punishment was limited. Now it is to some extent. That is the state. That is my reading on my, according to the workman. If you go paragraph 34.
Yes.
Paragraph 34 of Firestone. Let me read it again.
Yes.
Yes. Now here is the workman contended after second insertion of section 11, everything has been changed. But the management contended, no, not everything, but minor changes in part. Minor. And the contention of the management council was accepted. Now, if you lordship go through paragraph 34 and 35, it will suffice. Magic, sir. Thus, it will be convenient. It will be a convenient stage to consider the contents of section 11A. to invoke section 11A, paragraph 34.
Yes, yes.
To convoke section 11A, it is necessary that Indian industrial dispute of any of the type mentioned therein should have been referred to an industrial tribunal for adjudication. In course of such adjudication, the tribunal has to be satisfied that the order of discharge or dismissal was not justified. If it comes to a conclusion, the tribunal has to set aside the order and direct the reinstatement of the workmen, and on such terms as it thinks fit. The tribunal has also power to give other relief to the workmen, including imposing of lesser punishment, having due regard to the circumstances. The proviso, here comes the proviso.
Yes.
The proviso casts a duty on the tribunal to rely only on the materials on record. Materials on record. Now, what is the materials on record? That has been explained. The proviso casts a duty of to rely only on the materials on record and prohibits it from taking any fresh evidence. Even a mere reading of the section, in our opinion, does include that, in our opinion, does include that a change in law as laid down by this court has been effected. According to the workmen, the entire law has been completely altered. Whereas, according to the employer, a very minor change has been effected, giving power to the tribunal only to alter the punishment. After having held that the misconduct is proved, if the misconduct is proved, then also misconduct is proved. That is, according to the employer, the tribunal has the mere power to alter the punishment after it holds that the management is proved, misconduct is proved. The workmen, on the other hand, claim that a law has been rewritten. We cannot accept the extreme contention advanced on behalf of the workmen and on behalf of the workmen and the employer. We are aware that the Act is a beneficial piece of legislation enacted in the interest of the employees. It is well settled that considering the provisions of a welfare legislation, courts should adopt what is described by a beneficent rule of construction. If two constructions are reasonable or possible to be placed on the section, it follows that the construction which furthers the policy of the object of the Act and move the beneficial to the employees has to be preferred. Another principle to be borne in mind that the Act in question, which intends to improve the safeguard of the service condition of the employee, demands that the interpretation of the liberal enough to achieve the legislative purpose. But we should not also lose sight another canon of interpretation, that a statute for the matter that even the particular section has to be interpreted according to its plain words and without doing violence to the language used.
Mr. Dasgupta, to
Yes.
cut things short, here, if we come to the award, the last part of the award, the reference to only Indian Iron and giving his findings, that may not be held to be, does not appear to be justified. Because the learned judge has taken only 4 conditions, wherein he thinks that these are the only conditions wherein dismissal can be interfered with. But that does not appear to be in consonance with 11A, the substantial portion. 11A says that whenever you feel that it is not justified, you can interfere with a dismissal or a discharge order, and you can also have the power to or give some, suggest or impose some lesser penalty. So that part, there is no difficulty on this court for interfering on that part. But what about the evidence?
No evidence.
No. The evidence which are on record, the evidence which have been taken into consideration by the Learned Labour Court, which has considered the domestic inquiry.
Whether it is a material on record or not, you have conducted an inquiry. You just place this inquiry before this court. no witnesses came forward.
No, the coming of the witness, it may be a fault on your part. You have objected to it.
Yes.
Management wanted to have the evidence of the inquiry officer.
Hmm.
There was an objection. And your objection or not, that stop alone
That
cannot.
is, whether my objection
No,
is
no,
correct or not,
that may not be that.
It should not be correct. I may be wrongly objected.
Because there is no stop in law.
Ah, yes,
There
yes,
is
yes.
no, but the labor code itself has said that we will not allow.
Oh, yes.
That when the
Ah,
labor
l-
code has said that it will not allow, then how can you find fault?
Mm. Suppose what is the material on record? Written statement, undoubtedly,
Yes.
additional written statement,
And the evidence.
and the evidence.
Evidence were placed before the labor
Evidence,
court.
evidence by what way? Evidence somebody should come, if your lordship come to section
No,
11.
no. There is a distinction between the evidence in the domestic inquiry and the evidence before the learned labor court.
Ah,
It is true that before the labor court, there was no evidence adduced,
ah.
but the entire proceedings of the domestic inquiry was placed before examination before the learned labor court. It
Ah.
examined.
Exactly.
It found that the
Whether it
conclusion-
will be a part of evidence or not.
it is definitely the evidence, but yes, you may be correct. That ought to have been proved by the inquiry officer that I had conducted the inquiry.
Or inquiry officer or any other person, that this is the material on record which are in our disposal. These are the paper, this is the charge sheet, this is the reply, this is the examination in chief.
But that part of the award where he has relied upon the proviso, that also may not be held to be gross interpretation. It appears that provided that in the proceedings under this section, the labor code or tribunal shall rely only on the materials on record and shall not take into fresh evidence.
Yes. Well, one thing is very
If we
much clear.
understand in this manner, we cannot find fault with him.
Yeah, no. Look, whatever. An inquiry may be defective and an inquiry may be proper. So 11A will come only when the inquiry is proper. Not otherwise. Now, prior to 11A, if the inquiry is proper, you can interpret for certain ground, only certain ground. That is indicated in Iron's AIR 58 SP page 1.
No, but that has been overcome by 11A.
Yes,
Iron says that only on 4 conditions.
4 conditions.
And learned labor code unfortunately has only taken into
let us
account
forget-
those
let us
4
forget
conditions,
whether-
nothing else.
Huh.
He has ignored 11A.
All right. But when you are exercising the power under 11A, when you can exercise? You can exercise only when it is found to be fair,
Justified.
justified.
Yes.
Otherwise not. So, now how it can be justified? No, my lord.
No, let us read 11A.
No,
First part, first
before
part.
prior to 11A, let us go. We should not to this court. I should not read all those judgments because the one. But the loose book thing is that an employer dismissed an employee without holding an inquiry, or an employer dismissed an employee with holding an inquiry. Both this case, even if he dismissed an employee without holding an inquiry, he can straightway
He
give
gets a
evidence.
chance to adduce evidence.
Evidence,
Correct?
correct?
Yes.
All right. Now, if he has dismissed an employee by holding an inquiry, then he can rely upon this
Correct.
with an option that if my inquiry is held to be unfair, then I should be allowed to adduce evidence on me. This much. Now, this found that inquiry is fair. If the inquiry is fair, no question of adducing evidence will come.
Correct. Correct.
No question of adducing evidence is found. But if inquiry is fair and order of punishment is not proper, in that event also, no question of adducing evidence will come. Everything has to be appreciated on the basis of the material.
Material record. You are correct.
Material, that is why it has made clear by the proviso Only thing is that when the additional evidence will come, take into account, when the inquiry is unfair. But if the inquiry is fair, but the labor code will consider the মানে substantial portion of 11A, except
But,
proviso, it is very
no,
much clear.
Your submission appears to be very reasonable, but somehow
No, I have gone through some judgment. Lord.
no, the language does not indicate that this exercise to which may be undertaken by a labor court or tribunal to consider what lesser penalty can be imposed. This exercise is not the only subject matter of the proviso. Proviso says that in any proceeding under this section,
No.
and section refers to the proceedings of adjudication, which is a reference, or maybe a two-way proceedings also.
Now, last line. Now, if proviso should be connected with the last sentence.
Yes.
What is the last sentence? Last
Provided
sentence.
in any proceeding.
No, last sentence is including the award of lesser punishment in lieu of discharge or dismissal as the circumstances of the case may require. Proviso will guide this thing only.
No.
Where an industrial dispute relating to a discharge or dismissal to workmen has been referred to a labor court, national tribunal for adjudication, and in the course of adjudication proceeding, the labor court, tribunal or national tribunal, as the case may be, satisfied that the order of discharge or dismissal was not justified.
Not justified. First, it has to come to a finding that it is not justified.
Not the order of dismissal, not
Yes.
the inquiry.
Not the inquiry.
Yes.
Order of dismissal. And this is not confined to these 4 conditions laid down in Indian Iron.
Yes, yes.
It can come to any other conclusion.
Yes.
That is not justified.
That's not justified. There is a comma.
Yes.
Next, second part of the sentence.
It may.
Second part, my proviso comes to second part. It may, after comma, it may, again comma, by this award, set aside the order of discharge. So what is that? The labor court come to a conclusion that
The dismissal is not justified.
It is one part.
Yes.
And second part is segregated by a comma.
Yes.
What is the comma? It may, again, by its award, set aside the order or discharge or dismissal or the dismissal and direct the reinstatement of the workman on such terms and conditions as, if any, as it thinks fit.
Then or.
As it thinks fit, then or.
Then or.
That is in case
He
of.
may, he may not.
He may not. Reinstatement is not possible. He can give some compensation. Just now, Your Lordship passed an order in case of Mili Hazarika's case. That so far back wages is concerned, Your Lordship has reduced it. So, to some
That is not back wages actually. We are not even, we not interfered with the dismissal. It's not a question of dismissal. That was a different matter.
Okay. As it thinks fit. All right. Or give such other relief of the workman, including the award of lesser punishment. So, punishment of award of reinstatement or award of any other thing, lesser punishment, in lieu of discharge or dismissal, except discharge or reversion, stoppage of increment, all these things may be considered as the circumstances of this case may require. Now, while doing so, when you are interfering your power under 11A, while doing so, the proviso will come into play. Provided that in any proceeding under this section, section is 11A. 11A is for the purpose of reduction of the punishment. The labor code.
No, 11 is not for reduction. 11A is also having a power of reduction, but substantial power is to interfere with an award of dismissal or discharge. That is the power.
Yes.
In exercising that power, you can also direct imposition of lesser penalty.
Lesser.
That is an additional power given by 11A. But substantial power is for interfering with discharge or dismissal, which in the case of Indian Iron was limited to only 4 aspects. Only to overcome that, if the labor court or tribunal comes to a finding that it is not justified, then it can interfere.
So it should be interpreted after reading, going to the ratio laid down by the Indian Act.
Yes, yes, exactly.
So Indian Act what said? Yeah,
Only 4 conditions.
inquiry is fair. Then you can interfere.
We can just read it for you. It will interfere on 4 conditions.
Yes.
Number 1, when there is want of good faith.
Good faith.
Number 2, when there is
There is a
victimization or unfair labor practice.
Mm.
Number 3, when the management has been guilty
Of
of a
basic
basic
error.
error of a violation of the principles of natural justice,
Mm.
when on the materials of the finding is completely baseless or perverse. The legislature thought that these were giving a restriction on the powers of the labor court. To overcome that, 11A says that if you come to a finding it is not justified, you can interfere.
Ah.
And while interfering, you can also give lesser penalty
So
instead of a reinstatement.
So when even the inquiry is justified, the inquiry is fair,
Fair.
then also you can interfere with the punishment. Even the inquiry is fair. So far earlier as Indian Iron's case is concerned, that if the inquiry is fair, you cannot interfere. You can interfere only on this paragraph.
Yes.
Now this ban has been lifted.
Lifted. No, but to hold the inquiry to be unfair, he has to come to a finding that there is a lack of justification or it is unjustified.
No.
If the inquiry is fair, where is the question of that it's not being justified?
No, yes, that is the way.
These are
One
go
thing is
together.
inquiry is fair.
If the inquiry is fair,
Where punishment is
hold-
not justified. Inquiry is fair. There is a question of proportionality.
Yes.
Inquiry is fair, but punishment is not justified.
Hmm.
Huh?
Yes. Yes.
This law was prevailing before 1971, but for limited purpose. Now all these things has gone away. Now, yes, you can interfere. So only these things will come, for the proviso is concerned, Lord, only this thing will come only when the inquiry is found to be fair, or even then no inquiry was held. Management straightway came to the court and gave some
No, in this
evidence.
case, what do you contend? Is your contention? Are you trying to
Now I am clear. Now I am clear, Lord.
Yes.
I may be wrong, but I am
No,
clear.
no, are you trying to contend that the domestic inquiry was not fair?
So for this case is
Yes,
concerned,
yes.
my pleading is that
It was not fair.
not fair. No, let me clarify. And
No, if you say it's not fair, then you have to say that you are not given opportunity to adduce evidence or to cross-examine the witnesses.
Yes, I will come to it. No, Lord, I am now clear, Lord. An employer can dismiss his employee by holding an inquiry. And an employer can dismiss an employee without holding an inquiry. If, let us come to this conclusion. If he dismissed an employee without holding an inquiry, what will be put? Then the management can come to a conclusion. Come to a conclusion, yes, the inquiry which you have conducted here. If we go, let me keep it all. Inquiry which you have conducted here
In the labor court.
in the labor court. Inquiries are two called domestic inquiry and the labor court inquiry. The inquiry which you have conducted here, we have conducted here, that is a fair. Workman was afforded with all opportunity of being heard.
Just like a trial, it
Right.
works as a primary authority.
Private other.
If you are examining the fairness, you are acting as a secondary authority. If you are examining yourself, evidence before you, then you are acting as a primary authority.
Evidence.
Okay.
So it is fair.
Hmm.
Now, even if it is a fair inquiry, then also whether the punishment which was inflicted on the delinquent is
Hmm.
justified or not.
Hmm.
That stage has come.
Yes, yes, yes.
While taking up this stage, no fresh evidence is.
That we have got. That we have understood.
So if an inquiry is held to be fair, but punishment is not there, the domestic inquiry, not the inquiry by the court. Domestic inquiry. Domestic inquiry is held to be fair.
But punishment is held to be disproportionate.
But
At
while
that stage,
this is
there is no question of evidence again.
evidence. That is the gist of-
But immediately my question from the court would be, the charges appear to be very grave in nature. You not only gherawed, you assaulted, you tried to set him on fire. It's not a question of having an unlawful assembly.
yes, that question I will still come to.
We have not seen medical evidence on what he has said. MW1 management.
No,
will-
Bilal, what happened here? 300 to 400 workmen kept. Now, out of these 300 to 400 workmen, the management picked up 15 or 12 workmen.
12. Yes.
12. So the question is that whether these 15 or 12 workmen directly involved in. Yes,
The MW2 has the person who has sustained the injuries. He has named this.
named not for all parts. Four.
Most of them he has named.
No, only 4 parts.
No. MW1 has said 4.
Hmm.
That person who was not there. But MW2, Mr. Gogoi.
But whether there shall be these things shall be considered on material on record or not. Because, my lord, you have conducted your domestic inquiry. And this domestic inquiry has to be established that you conducted this domestic inquiry in a fair way. So you have to produce this inquiry before the labor court to the procedure established by law. Or simply because by producing some document, whether it is permissible or not. For that purpose, Industrial Dispute Rules 1958 is there. I may be wrong, but let us for the timing assume that yes, the misconduct is it very grave in nature. But one must establish it. We were implicated in a criminal case. In that criminal case, well, all of us were acquitted. My friend's case is that it is acquitted because we could not establish this case. Now, we were implicated.
No, he says that it's benefit of doubt.
Benefit of doubt. So, let us examine this thing. After content by today.
And even which you had indicated, the standard of proof is also different.
Yes.
One is beyond all reasonable doubt. One
Beyond
is
reasonable doubt and
so one is preponderance of probabilities.
So one thing is that whether your lordship can take cognizance of this material without introducing the same to an evidence.
Okay, that you have submitted, that we have taken into consideration.
Now, my lord, so far criminal case is concerned, page 26
of the
writ petition.
Okay. 26, yes. That judgment of the criminal court. That we have taken into note, acquitted. failed to establish beyond all reasonable doubt at page 29, acquitted.
On what ground it was acquitted? Whether it is honorably acquitted?
Not honorably,
Not
benefit of doubt.
benefit of. Page 28. Huh? It's not all.
Under the circumstances, prosecution failed to establish the case beyond all reasonable doubt. The accused persons are not found guilty under such and such.
In the criminal case, Jiten Gogoi was not examined.
JK Gogoi,
JK Gogoi.
MW2.
MW2 in the inquiry. Because
No, Assistant Manager Jiten Gogoi tried to plead.
no, it is the statement of some other way. The Lordship may come to page 28. It says, this paragraph, on the other hand, in spite of taken all efforts to bring Jiten Gogoi in the witness box by the prosecution, Jiten Gogoi had never appearing in the witness box, and the reports on the summons issued against so-and-so disclosed that he had avoided from appearing in the witness box. Summons issued on so-and-so against Gogoi rather disclosed that he was no more interested in deposing in the proceeding against the accused. Maybe, yeah, or I don't know. But there is a difference that the main victim was not examined in the criminal.
Okay, yes.
Two other points that I have to look into, my lord. If your lordship will give me some time, lord,
What issue?
on the fairness of the inquiry. On 5 minutes, next day.
No,
Tomorrow.
we'll complete it today. We can give you some time to.
Oh, let him argue.
Then.
Yes, that will be better.
Was that given sufficient time?
So, yes. I will make my.
So, my lord, first I would like to submit, my lord, this 11A.
Just a
is-
minute, just a minute. Yes,
This 11A is not the pleaded case. my
you're
lord.
for the management.
Management matter. It is not the pleaded case.
11.
11A is not the pleaded case. So everything that has been argued is not there in the writ petition. So, my lord, that way I'm not fully prepared to address on this issue. But what is the pleaded case? Before the labor court, the written argument, if your lordship goes to the record, the workman's case is that they were given a vague charge sheet.
They were?
Given a vague charge sheet. Charge sheet did not disclose any offense. That is the only case. Here they have pleaded three things, my lord. Number one, inquiry officer not examined. Number two, cross-examination was not allowed. That management witnesses were not allowed to be cross-examined by the witnesses, by the workman. And three, inquiry report was not given. I take your lordship to this aspect first. Now, my lordship will come to page number 6, paragraph 16. The first,
Here in the petition, you said three grounds.
yes.
One
See,
is-
one, first, that inquiry officer was
Not-
not examined in the labor court.
Hmm.
Number two, witnesses
Not allowed to cross.
were not allowed to be crossed by the workmen in the inquiry. And third, my lord, they have questioned the action of dismissal on the ground that the findings of the inquiry was not communicated to the work.
No inquiry report.
No inquiry report. That, your lordship, may I draw your lordship's attention to paragraph 10, page 4. 9 and 10.
Page
Number 4,
of
9
the
and 10.
repetition.
Yes. First, paragraph number 9. The workmen that after submission of written explanation by the workman, management conducted domestic inquiry by appointing one so and so as inquiry officer. Domestic inquiry was held on such and such date, and the office of the in the office of the manager, general manager, Ananda Tea Estate. The management examined as many as 11 witnesses in the domestic inquiry. The workmen were not provided any opportunity to cross-examine the management. Paragraph 9.
Paragraph 9.
My lord. This is a specific stand that the workmen were not allowed to cross-examine. That is, their attack is on the fairness of the inquiry. Number 2, paragraph 10,
Yes.
that on the basis of the findings of the inquiry officer, management of Ananda Tea Estate dismissed 12 workmen from their service on 11/8/2004. It is pertinent to mention here that the workmen were neither provided any opportunity to submit representation against the inquiry report, not provided any opportunity to submit representation against the proposed punishment. My lord, that issue of proposed punishment is not there in the industrial matter. It is there in service rule. Some service rules say
Even that has been abrogated after
so-
42nd
Yes.
Amendment.
Now, the only thing is their contention is that no report was communicated. For that, we have filed an affidavit. We have denied this, and lordship may have a look at the record
Affidavit in this writ petition.
in the writ petition.
Page. And what about, where is the pleadings regarding inquiry officer not examined? That paragraph, you have not. You
Yes.
said they have taken three grounds in the writ petition.
Yes, that inquiry officer was not examined. My lord may come to paragraph 18 at page 6. The examination of the inquiry officer in a proceeding for adjudication of the issue of fairness of domestic inquiry is sine qua non. But in the present case, inquiry officer was not examined,
Okay.
has failed to appreciate this.
Okay.
Now, my lord,
Your affidavit.
yes. My lord may come to page 6. The inquiry officer conducted the
Paragraph,
inquiry.
paragraph.
My lord,
Second-
page
second
6,
second
it is the
part.
second paragraph, and it is not
Yes.
numbered in that way.
Yes, yes.
It is the paragraph. Inquiry 6. Conducted the inquiry in full compliance of the principles of natural justice, and full opportunity was given to all the workmen to defend themselves. It is stated here that at the beginning of the inquiry officer had explained the workmen the procedure of inquiry, the contents of the charge sheet, and replies to the charge sheet. Upon a specific query made by the inquiry officer as to whether the workmen had understood the charges level, all of them replied in affirmative, meaning thereby that the charges leveled against them were very much clear to them, and the witnesses were examined in the inquiry in the presence of the workmen. And most of the witnesses were cross-examined by the workmen, barring a few whom they declined to cross. Now, lordship may have a look at the record, that page number 74 onwards. This is the record of the labor code. MW1 in statement in the inquiry, and page number 74, the cross of the workmen of MW1 in the inquiry. Again, MW2 was examined, that is JK Gogoi, 82 to 88, page number. This workman cross-examined that witness. MW3, His cross-examination, page number 92 to 95. Cross-examination MW4, page 99. My lord, cross-examination of MW5, 104 to 106. But cross-examination of 6, 7, 8, 9, 10, and 11, they have declined. Some and declined. So first thing, my lord, this is absolutely a incorrect statement. Rather, I would like to point out that is a false statement. My lord, the next ground that inquiry report was not communicated. Lordship will have a look at page number 172, 183 of the record. Here, my lord, the inquiry report was communicated to all the workmen, individual letter, and they received it. And in reply, that is page 184 to 195 of the record, the workman has submitted a representation or reply saying that it was a biased inquiry, partition inquiry. So here also, my lord, this is a wrong statement, rather a false statement. Now, before going into other issues, my lord, I'd like to submit one thing. In a equitable court, Lordship is aware of the K.D. Sharma's judgment. Making of a false statement or incorrect statement closes the door of equitable relief of the petitioner. So I'll rely on the judgment. So they have not two grounds of challenge. It is from the record that it is not correct. So far, the examination of the inquiry officer is concerned, what we have seen, that order of 8/9/2012. The management wanted to examine, they objected to it, and they have accepted, my lord. So far, the argument of my senior counsel that no witnesses were examined to bring on record those documents, the workman has not objected to it. They have not objected. My lord, evidence to prove this document comes when there is a dispute with regard to the genuineness of the document. Both sides agreed. Labor court said that, okay, bring those materials. Workman has appreciated, agreed to it. They objected to the examination of the inquiry officer, and they proceeded to submit the written argument. Now, my lord, on one side, it is objected that the evidence cannot be laid of the inquiry officer, and a reverse argument is made in the High Court, saying that it was wrong on the part of the labor court. That is not permissible. Now, what will be the materials on record so far this case is concerned? If your lordship once again takes that Firestone's judgment, paragraph 48 and 49,
Yes.
849, which my senior had earlier referred and read. We are not inclined to accept the above contention of Mr. Deshmukh. The proviso specifies matters which the tribunal shall take into account as also matters which it shall not. The expression materials on record occurring in the proviso, in our opinion, cannot be confined only to the materials which were available in the domestic inquiry. On the other hand, the materials on record in the proviso must be held to refer to materials on record before the tribunal. They are the evidence taken by the management at the inquiry and the proceedings of inquiry. Now, my lord, that has come in the record. Placing of those materials were not objected to by the union. They agreed. They objected to the examination of the inquiry officer. They agreed to get this matter heard on the maintainability of the fairness of the inquiry on this material. So the evidence taken by the management at the inquiry and the proceedings of inquiry. Number two, the above evidence and in addition, any further evidence laid before the tribunal. Now, lordship is aware that further evidence can be laid before the tribunal or the labor court only when the inquiry is held to be unfair. Before holding the inquiry to be unfair, there is no question of leading any additional evidence other than the evidence or the materials of departmental inquiry. And evidence placed before the tribunal for the first time in support of the action taken by the employer as well as the evidence adduced by the workman contract. Now, my lord, the third situation is where no inquiry was held. And the allegation is sought to be established in the court for the first time. Now, here it is a case where the materials of domestic inquiry were placed before the court. And the situation of leading or reducing evidence did not arise at all because it will come only when the inquiry is held to be unfair. So, my lord, these materials of inquiry was sufficient for the court to take a call as to whether the inquiry was fair or not. Now, my lord, how an inquiry is held to be fair? Is it that violation of natural justice will automatically make an inquiry unfair? No. Here, my lord, lordship is aware of that State Bank of Patiala's case that is reported in 1996 3 SCC 364. So after relying on all the judgments earlier, has examined this issue. May I read, my lord? Now, coming back to the illustration given by us in the preceding para, which would setting aside the punishment and the entire inquiry on the ground of aforesaid violation of subclause. The interest of justice equally demand, it is paragraph 32, demand that the guilty should be punished and the technicalities and irregularities which do not occasion failure of justice are not allowed to defeat the ends of justice. Principle of natural justice are but the means to achieve the ends of justice. They cannot be perverted to achieve the very opposite end. Now, paragraph 33, my lord. We summarize the principles emerging from the above discussion. An order passed imposing punishment on an employee consequent upon a disciplinary departmental inquiry in violation of the rules, regulations, statutory provisions governing such inquiries should not be set aside automatically. The court or the tribunal should inquire whether the provision violated is of substantive nature or procedural character. Now, if it is a substantive nature, then it will be different. Procedural part, it will the test of prejudice.
What is the citation?
My lord, 1996 3 SCC 364. State Bank of Patiala and others versus S.K. Sharma. Now, though in this case, nothing could be established that there was any violation of any procedural aspect, apart from 2 allegations or 3 allegations that not allowed to cross-examine and no report was given, that turns to be an incorrect statement. Now, even if there is some violations of the procedural aspect, that by itself not vitiate the inquiry, my lord. Now, I am reading, my lord. In the case of violation of a procedural provision, the position is this. Procedural provisions are generally meant for affording a reasonable and adequate opportunity to the delinquent officer employee. They are generally speaking conceived in his interest. Violation of any and every procedural provision cannot be said to automatically vitiate the inquiry held or order passed, except cases falling under no notice, no opportunity, and no hearing categories. The complaint of violation of procedural provisions should be examined from the point of view of prejudice. Whether such violation has prejudiced the delinquent employee in defending himself properly. If it is found that he has been so prejudiced, appropriate orders have to be made to repair and remedy the prejudice, including setting aside the inquiry and or the order of punishment. If no prejudice is established to have resulted therefrom, it is obvious no interference is called for. Now, so far these labor matters are considered. Now there's another this clause 5, point number 5, where the inquiry is not governed by any rules, regulations, statutory provisions. Now, which is normally in industrial matters. And only obligation is to observe the principles of natural justice, or for that matter, wherever such principles are held to be implied by very nature and impact of the order action. The court or the tribunal should make a distinction between a total violation of natural justice, rule of odi alteram partem, and violation of a facet of the statute, as explained in the judgment. In other words, a distinction must be made between no opportunity and no adequate opportunity. That is between no notice, no hearing, and no fair hearing. In the case of former, the order passed would undoubtedly be invalid. That is, if no notice, no hearing, nothing is done. But if notice and hearing takes place, in such cases, normally liberty will be reserved to the others. But in the latter case, the effect of violation of a facet of the rule of alteram partem has to be examined from the standpoint of prejudice. In other words, what the court or tribunal has to see is whether in the totality of the circumstances, the delinquent employee did or did not have a fair hearing, and the orders to be made shall depend upon the answers to the same. Now, here is a case, Lordship will go through the record, going through the record, will see the inquiry was held. In the inquiry, before initiation of the inquiry, they were given charge, where the charge was specifically and clearly spelled out. The allegation was you on 30/1/2004, you have assembled and attacked, assaulted friends. Inquiry was held. Witnesses were examined in the presence of the charge-sheeted employees. They cross-examined the relevant witnesses and some they declined. So here it is a case where it cannot be said that no cross-examination was allowed. After the conclusion of the evidence of the management, they were given the opportunity and they examined themselves as witnesses. That is also there in the record. These workmen examined themselves as witnesses.
How many witnesses?
My lord, it is there, but I cannot exactly give the page number because I have not noted it. But I have seen it. They have examined themselves as witnesses. A record on completion of inquiry, a finding was recorded by the inquiry officer wherein it was held that the charges were executed. It was communicated and they have not questioned that finding on any violation of procedural part or perversity. And ultimately, a dismissal order was issued against all this person. Before the labor court, it was not their case that the inquiry was bad for violation of these things. Their only case before the labor court was, it was bad because vague charge sheet was given and they could not understand the charge sheet, charges leveled against. They appeared and Lordship has seen that 9/10/2012 order. Now here the labor court has seen, labor court has examined the materials of inquiry and came to a finding that the inquiry is fair. Now it is not even their case that the findings of the inquiry is perverse. The workmen in their pleadings have not submitted that the finding of the inquiry officer is perverse. If I have understood the law correctly, an inquiry, findings of an inquiry is challenged on two parts. One is procedural irregularity and other is perversity. If an inquiry is conducted unfairly, if the procedure is not properly followed, then the inquiry is vitiated. Even if the procedure is properly followed, but the finding is contrary to the evidence on record, then it is a perverse finding. Now, it is not the case of the workman that the finding of the inquiry officer was perverse. Nowhere, I have not seen this bit. So, labor court recorded a finding that inquiry is clear. Now, Lordship may come to page number 21. Here, this S.K. Sharma judgment was also taken note of. Therefore, in such situation, my lord,
Where are you reading?
my lord, it is the first, second, third paragraph. Therefore,
Page?
page 21 of the
Of-
writ petition.
Okay. Just a minute.
Therefore, in
Just-
such situation,
Just a minute. Okay. Therefore, there is no question.
there is in such situation, the management should not work and court also should not interfere unless there is nothing to interfere in such situation. It is also submitted that by the learned advocate for the management that it is the duty of the management to maintain congenial atmosphere in the garden for smooth running of the garden. If the workman assaulted manager, confined the management official, in that case, there is no reason to show mercy. The management side. So and so. Now, here two decisions are relied. These two decisions are, my lord, this decision of 2006 1 SCC 430 is a case where the Supreme Court held assaulting a superior in workplace is grave enough where the punishment of dismissal will not be disproportionate. And this other case, my lord, the labor court has not expressed itself in so many words, but the other case that is relied, Akhil Bharatiya Cha Mazdoor Sangha and other reported in 2004 3 SSC. This is Krishna Kohli Tea Estate. Here also, my lord, the allegation of assaulting the manager.
Yes.
Now, the lordship has seen
Krishna-
11A comes into picture when the court finds that the inquiry is fair, but the punishment is disproportionate, shockingly disproportionate. Then only 11A can be exercised, my lord. Here in this given case,
Here, that expressions shockingly disproportionate is not in the statute.
Not
That's
in the
It's
statute.
not found to be justified.
yes,
Shocking disproportion is some expression used in a judicial findings.
Chaturbadi's case.
Chaturbadi's
and
case.
another thing also.
Mm.
Now, that justification, in the face of this allegation having been established in a fair inquiry, whether the dismissal will be disproportionate to the allegation. Even if, my lord, the tribunal or labor court did not exercise that power, your lordship can always examine in the context of this case, whether in the facts and circumstances of the established facts, whether the punishment will be a disproportionate punishment. These two judgments will throw light that in case where a person or an employee misbehave or assault his superior at workplace, then the punishment of dismissal shall not be disproportionate. Here is a case where the finding is not questioned. The procedural part was questioned, which turns out to be incorrect. It is not a case of no opportunity, no evidence, or no, my lord, fairness. So, my lord, in this case, the charge was established in the inquiry. The charge is grave enough, and the management decided to impose the penalty of death. This issue of justification of the punishment, the court can, but in the present facts and circumstances, whether it appears to the court that that order of punishment is disproportionate. If it is not, then there is nothing wrong in the order of punishment. Now, my lord is aware that in matters of finding recorded by the labor court, a 226 court, a writ court, will not substitute his finding. Now, just I'm reading one paragraph. Normally, the labor court or the industrial tribunal, as the case may be, is the final court of fact.
Which one?
My lord, 2005, 3 SST 193.
Name? 2005 3 SCC.
Yes, 193. Management of Madhurantakam Cooperative Sugar Mill versus S. Viswanathan. Normally, the labor court or the industrial tribunal, as the case may be, is the final court of fact in this type of dispute. But if a finding of fact is perverse, or if the same is not based on legal evidence, the High Court exercising power either under 226 or 227 can go into the question of fact decided by the labor court or the tribunal. But before going into such an exercise, it is necessary that the writ court must record reason why it intends considering a finding of fact. In the absence of any such defect in the order of the labor court, the writ court will not enter into the realm of factual disputes and finding given thereof. So, my lord, what I would like to submit, labor court has recorded a finding that the inquiry was fair. That was recorded on the basis of the materials of inquiry. In that case, to substitute the finding of the labor court on any other ground other than the ground of perversity may not be correct for this honorable court to under exercising the power under 220. So, my lord, here it is a case where these workmen were all involved in gross misconduct. The nature of misconduct was severe enough. So, the finding recorded in the inquiry where the charges were held to be proved, it is not their case that the finding of the inquiry officer is perverse or is based on no evidence or irrational finding, which has been upheld by the labor court, accepted that finding. In that scenario, the argument of non-exercise of 11A, to my submission is, my lord, not at all acceptable. 11A will come only when the punishment is disproportionate. Or court must satisfy that the punishment was not proper. Inquiry was fair, charge established, but the punishment was
Not justified.
not justified.
And not punishment of dismissal and
Is
discharge.
not justified. So, indirectly, my lord, to say or come to a finding that the punishment of dismissal is not justified, then it goes to the proportionality. Without that itself is the examination factor, proportionality. It is only when the court says it is disproportionate, then it can say that the punishment of dismissal is not justified. So here in this case, your lordship will see whether in the present.
Let us see the findings of the labor court in coming to a conclusion that the penalty of dismissal in this case is justified and commensurate to the gravity of the offense.
My lord, that is something which the labor court has not expressed it in so many words. The labor court lordship will.
No,
while going to-
after discussing these two cases,
Yes.
there is some
There is
discussion.
something, it is submitted that at any stage, the management should maintain peace administration. So
Proper administration.
proper administration for garden, for smooth functioning of the garden. In such situation, dismissal of a workman is not shockingly disproportionate. So dismissal of the workman, it is justified in accordance with law in such situation. So, my lord, considering the submission of both sides, I have found that the management side, their submission has a force. So, he has accepted that submission that the overall situation where the allegation is this, which was established, the punishment of dismissal is not shockingly disproportionate was accepted by the labor. Considering the submission of both sides, I found that the management side, their submission as a force, and also that the evidence of the management side, it is found that that acceptable, and accordingly in between two views, I have accepted the management view, and it is found that there is nothing to hold that the principal is not followed in the case, and it is found that so and so has laid down by so and so. My lord, somehow he could not express himself in so many words, but if we read the award as a whole, we can draw a conclusion that the labor court has accepted the submission of the management, that in view of this allegation which was held to be established, and keeping in mind the overall administration and discipline in the garden, the punishment of dismissal is not shockingly disproportionate. So, my lord, in a different way, labor court has come to a finding that the punishment of dismissal is justified. It has not come to a finding that it is not justified.
I think there was no requirement to refer to Indian Iron
My lord,
after
My lord,
58, after 11A was incorporated.
lordship
this
will,
was-
if your lordship goes to the award, if your lordship sees the writing of the award, it is very difficult to sometime understand what the
No, this
officer is trying to do.
this award is of which date? Award is of
2015.
15, and in 15, if you are not,
Not 15, it is of 2000.
8,
2012, 8, 10,
2012. 2012. And if 8 and 2012, you are relying upon Indian Iron without taking into consideration 11A, which has been incorporated to overcome Indian Iron.
That is,
That is not.
but as a whole, my lord, he has done, that is one aspect. But
No,
as
this part, you see, this was wholly. Let's come to the last part of page 22. After discussing that the preliminary is decided in so and so, therefore I feel that they haven't entitled.
they have entitled no order of the
the
register
review
with full
fully.
backward.
Thereafter, was there any requirement
No,
of?
ma'am. It was not required. Even, my lord, even it was not, but ultimately what is required to be done, he has done it, but in a different manner, or he could not express it in so many words. He has taken note of the submission of the council for the management that this is not a punishment where it is shockingly disproportionate. It is not a case where the punishment is not justified. He accepted that view and came to a finding that they are not entitled to reinstatement with back wages. Now, coming to the, once again, I would like to submit before a lordship that these materials of inquiry, the workmen have not disputed this.
We have already submitted that.
This document. So merely because no person was called to prove this document, that itself will not vitiate the proceeding of the labor court. That too in a case where they have themselves
Is
objected.
there anything on record to substantiate your submission that the contents of the domestic proceeding was there? It was an admitted position.
No, my lord. Admitted in the sense when the labor court on 9/8/2012 passed that order at accepting their argument that the inquiry officer need not be examined. And it was, if your lordship goes to that order, it was lastly held that the inquiry has to be established from the materials of inquiry, fairness of the inquiry, and the preliminary issue was framed. And both sides were directed to place their argument. Workmen did not object to it. They did not say that no, these documents need to be proved. Rather, they have accepted that order. They have filed the written argument. Management filed it.
No. That will have difficult to accept. Simply by they not saying anything will not mean that they have admitted.
But no, they have not disputed even. My lord, they have not, it is not the case of the workmen that no inquiry was held, or this proceedings of inquiry is a fabricated material.
Let's see the written statement.
My lord, I am handicapped, my lord. I don't have the written statement. I have only the writ petition, my lord. In that case, it is there in the record.
Just a minute.
They have not questioned the inquiry. It is not their case that the inquiry was not
Have you
held.
annexed the written statement?
No, it was not annexed. It is there in the record.
Just
So for the workmen are concerned, my lord, three different arguments. My lord. First, in the labor court, they say that the charge sheet is vague, so inquiry is vague.
just a minute, just a minute. Yes. Vague.
They have accepted the fact that inquiry was held. They participated in the inquiry. Witnesses were examined.
Where is the evidence of Gogoi?
My lord, he is MW2 in the inquiry. The cross-examination starts from page number 82, so at least 4-5 pages. I think it will be around 75, 76. Is the, huh? 75, 76. My lord, it is paginated by the labor court. This is that with that reading. Okay.
Okay, we conclude or what? Mr. Dasgupta would like to add anything more?
And my lord,
The only thing is that whether it, oh, sorry.
I will rely on judgment of this K.D. Sharma, that is 2008.
Allahabad.
No, that making a wrong false statement.
That was from Allahabad, I think.
I'm giving the citation 2008, volume 12, SCC 481. And relying paragraph 34, 35, 36, and 38. 2008.
Court of Equity.
Yes. Whoever comes to the writ court and makes false statement, the Supreme Court said that one has to make all statements correctly, even if it goes against you.
Candid disclosure.
Yeah, you must disclose it. And making a false statement.
Citation, K.D. Sharma?
2008, 12 SCC 481. I'm relying paragraph 34, 35, 36, and 38. And similar line, it was followed in 2013 2 STC. Take note of it. 2013 2 STC 398.
Name?
Kishore Samriddhi versus something. Here, paragraph 31. Ultimately, the same thing. One should come and disclose everything fairly before the court, even if it goes against
He who seeks security must come with
clean hand. So, and if anyone is found guilty of making false statements, suppression of material facts, then no equitable relief can be granted. That is what we have urged in our affidavit, paragraph 10. We have taken a stand. And that has been taken, submitted in our affidavit. Lordship may come to page number 8, paragraph 10 of our affidavit.
Page number?
8, paragraph number 10. It is stated that the report of the inquiry officer dated so was communicated to the concerned workman by
Okay,
letter
today we'll
dated.
have to write, otherwise also we'll have a meeting.
My lord.
Will you,
Not tomorrow, day after tomorrow, my lord. Tomorrow is a Muslim day. Perhaps it
no,
will be-
tomorrow we can have it at around 3 o'clock.
Well.
Mr. Dasgupta? Tomorrow at 3 o'clock, Mr. Dasgupta?
Yes.
Is it okay for you?
Yeah, but tomorrow will be,
Day after tomorrow, we have got many matters fixed.
then tomorrow.
Tomorrow at 3 o'clock.
3 o'clock.
Then, no problem.
Heard so and so and so. Hearing has remained inconclusive. List again for further consideration tomorrow.
At 3 p.m.
We'll not say that we are just, it's up to you. If we get time earlier also, we can come.
Otherwise, 3
at
o'clock.
3 o'clock.
Obliged.
Yes, any matters where interim order is still today?
Allowed item number 5 is the Parthard.
5, yes, when we can have.
Then
Parthard,
can it come on 23rd?
Parthard, we do not make Parthard. How is this has become Parthard? Item number?
5.
Oh, Parthard, okay. Day after tomorrow?
23rd.
23rd, this court may not be there. 22nd, 2 weeks, this court is not there. Have it on 18th?
18th.
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 Paucity of time, huh? Yeah, list on 18th. 1.
My lord, similar pair, item number 8 and 9, the same issue with improvement, 8 and 9.
Same issue means?
Item number 8 and 9.
What same issue?
So this also relates to below, this relates to below cancellation of the.
This is a Parthard matter. What same issue? This is a 23 matter.
Issue is same below.
Maybe.
So cancellation of license.
Let this case be
Then
decided first.
20 that below, 20 that.
We cannot, 23 matter, we cannot fix a date. Any matter where interim order is still today.
My lord, interim is to be.
Item
1-5.
number 1-5.
In item.
For
15.
15. Well, one by one, 15 interim order.
A date may be fixed, I am for.
Item 15, tell us a date.
Malot on the, if possible, Malot then 30.
Not 30, we'll have it on 29th. 29th.
May I
Okay,
make
Mr.
a small, in item number 21, Malot, I have made a mention of the last it pertains to my statement of a victory.
Okay.
The last date is, my lord, it's about to be over, my lord, expired. So if your lordship is please to fix it on any date convenient, my lord,
You try on 23rd.
my lord,
23rd.
I'm deeply obliged.
Yes.
Item number 16, Lordship. February is Lordship, so may I be listed as 30th January, Lordship?
No, only matters where interim order is to today. We're not fixing any matters.
Lordship, I am paying for fixing the matter 19 on Friday, Lordship. In this case, we have already accepted the LOA, Lordship. Lordship, only limited prayer to Lordship and close the requisition with a direction to vigilance to consider
Which
our
matter?
Lordship, item number 19.
Okay, 19 Friday করেছি।
My lord, the item 6 and 7, my lord.
Yes.
Lordship had fixed the matter today on a hearing day, my lord.
Yes.
And there was an observation for disposing of the matter, my lord. And if it's possible, can it come up day after tomorrow? sir?
Day after tomorrow, many matters are fixed. Sorry. You try it on 23rd.
23rd.
My lord, my item also, my lord, 8 and 9, my lord, then another date, my lord. On 30th, my lord.
Is there any observation for disposal today?
Yes.
Where? Let us see. Let us see.
Printing complete, my lord.
Is there any observation for
Yes.
disposal today?
No, fixed for hearing.
Is
Admission
there-
hearing.
Yes, no?
Item number 8 and 9.
Admission hearing. Okay, এটা তো একটু লোক দিলে হন 8 and 9 along with item number 5 Okay.